You are good to go.
We're live. All right, we're back from our lunch. And the first thing I'm going to announce is that the bill that we just worked, which was 24 LSO 0052, is our vehicle that we're going forward with as far as ESA accounts. That's the committee bill. Oh, I should, yes.
So just a clarifying question.
Go ahead, Representative Berger.
So that is our vehicle, meaning that's that's a committee bill, correct?
Well, we voted to make a bill similar to that in the minutes on last time, as Representative Provenza pointed out. So
Okay.
it's just a matter of us working it next time with all the amendments. So I'm going to tell you to get your amendments in order for this bill and the next bill. And in our November meeting, we will go through those two bills and dissect them and bisect them and do what we need to do.
All right. Thank you, Mr. Chairman.
Okay. All right. So this bill that we're working right now is Parental Rights in Education 24 LSO-0076. Senator Beitman, would you like to have any opening comments on this bill?
You can have a hard copy of it. I could. Thank you. Thank you, Mr. Chairman. This bill was drafted by Senator Dockstader last session. It passed out of the Senate, didn't make it through the House. As you remember, at last meeting, I brought it up for discussion again because I think it's very important that we discuss parental rights in education. It's a hot topic in my community. I'm sure it's probably in yours as well. And so the bill draft should be almost identical to the last bill that you saw or may not have seen last session. So do you want me to walk through it, or is that what Tanya's going to do?
Tanya's going to walk through the bill.
Perfect. I'll stand by for fill in and back up if
Very
she
good.
needs it.
For you guys that just showed up, we went through the rules again, make sure everybody's aware of what the rules are and that we're all going to treat each other with respect and decorum. Ms. Hyde, Senate file not Senate file, it's 0076. Thank you.
Mr. Chairman, again, Tanya Heitrick, Legislative Service Office. I'll go ahead and walk through 24 LSO 0076, Parental Rights in Education, -1 period. As Senator Beitman mentioned, this is a resurrect of Senate File 117. Largely, there were a couple of changes. First of all, pushing out the school year an additional year, recognizing that obviously it will be the next school year at issue now. And then also eliminating the K-3 limitation on the health questionnaires, and I'll make a note of that, but that's on the second page. So at a high level, this bill outlines the obligations of school districts in communicating information relative to a student's mental, emotional, or physical health or well-being to their parents, and also prohibits classroom instruction in grades K through 3 regarding sexual orientation and gender identity. Moving on to the provisions of the bill, specifically onto page 2, line 4 through page 8, line 4, this creates a new statutory section 21-3-135. And moving on to the next lines in the bill, lines 10 through 19, this prohibits school districts and teachers or any other person on providing classroom instruction on sexual orientation and gender identity in all K-3 grades to all students in grades K through 3, or in a manner that is not age appropriate or developmentally appropriate for students in accordance with standards to be established by the state board. That's sort of one section of the bill. And then the second section of the bill begins on the bottom of page 2 with paragraph B, line 21. Through page 3, line 12, and this requires school districts to notify a student's parent or guardian if there's a change in the services or in monitoring a student's mental, emotional, or physical health or well-being. It also requires that procedures are adopted to reinforce the fundamental rights of parents to make decisions regarding the care and control of their children. Requiring a school district personnel to encourage a student to discuss those issues relating to his or her well-being with a parent or guardian to facilitate discussions with the parent. Page 3, lines 14 through 16 prohibits school districts prohibits school districts from prohibiting parents or guardians from accessing their students' educational or health records created or maintained or used by the school district. Page 3, lines 18 through 21, prohibits adoption of policies by school districts that prohibit school district personnel from notifying the student's parent or guardian about the student's mental, emotional, or physical health or well-being, or a change in the related services or monitoring. Page 4, lines 1 through 5, prohibits school districts from adoption of policies and procedures that encourage or have the effect of encouraging a student to withhold information from a parent or guardian about the student's mental, emotional, physical health, or well-being. Page 4, lines 7 through 17, effective school year 24-25. This is one of the changes that I mentioned. Requires, in each school year thereafter, requires each school district to notify parents and guardians of healthcare services offered or provided at the student's school, and provide the parent with the option to withhold consent or decline any specific healthcare service. Parental or guardian consent to a healthcare service is not a waiver to their right to access the student's educational or healthcare records, or their right to be notified in the event that there is a change to those services. Page 4, lines 19 through 23, before administering a student well-being questionnaire or health screening to a student, the school district shall provide the questionnaire or information of the health screening to the parent or guardian and obtain their permission to do so. This was one of the changes that Senator Beitman directed in this bill in Senate File 117. I think this was limited to grades K through 3. Page 5, lines 2 through 5, requires adoption of procedures for parents to be able to file a complaint in the event that the provisions of this section are not complied with. Lines 7 through 10, this is also provisions that identify that the Wyoming Administrative Procedures Act, in the event that there are provisions within this act or the procedures that are outlined that I'll talk about here in a moment, that the provisions within this statute control, not the Administrative Procedures Act. Moving on, lines 12 through 14 requires that a parent or guardian filing a complaint provide a copy of that complaint to the principal or the principal's designee. Line 16 through 18 requires that there is a resolution of this complaint within 7 days. Lines 20 on the bottom of page 5 through page 6, line 2, requires that if the complaint is not resolved within 30 days, the school district shall resolve it or otherwise provide to the parent a statement of reasons as to why it has not yet been resolved. Page 6, line 4 through page 7, line 7, outlines if a complaint is not resolved in accordance with the sections that I just discussed, a parent can request a hearing through an independent hearing examiner through the Office of Administrative Hearings, who will hold an administrative hearing to determine the facts related to the dispute and provide a recommended decision to the State Board of Education not more than 30 days after that complaint is submitted. The State Board is then required to accept or reject the recommended decision not later than 30 days after the date that they receive that recommended decision, or at the next regular scheduled board meeting, whichever is sooner. And the cost of that hearing and the hearing examiner will be borne by the school district. Moving on to page 7, lines 1 through 7, this also provides that a parent can bring an action against the school district seeking injunctive relief, and a court may award damages and shall award reasonable attorney's fees to a parent or guardian who substantially prevails in an action brought under this subparagraph. Page 7, lines 9 through 11 provides that a school district must adopt procedures to notify parents of the rights and procedures available to them under this subsection. Page 7, lines 13 through 15 provides that nothing in this subsection shall be construed to abridge other rights or remedies under law that may be available to parents. Page 7, lines 17 and 18 references the parental rights, and this is actually in Title 14, but under 14-2-206, there's sort of a catch-all provision for parental rights. And this just states that it should be implemented in accordance with that provision. Page 7, line 20 through page 8, line 4 provides that nothing in the section prohibits adoption of policies to withhold information if a reasonably prudent person would believe that disclosure would result in abuse as defined by Wyoming Statute 14-3-202A Romanet 2, or neglect as defined by Wyoming Statute 14-3-202A Romanet 7. Section 2, beginning on page 8 at line 7 through page 9, line 5, draws in the conforming provisions that are necessary to conform to the newly created statute that I just discussed. Lines 10 through 18 amends 21-3-304. This is the duties of the State Board of Education. This is to ensure that there's a reference to the hearing that I previously discussed on resolving those complaints. On the bottom of page 8, lines 20 through page 9, lines 5, this amends the duties of the boards of trustees contained in 21-3-110. Again, it's just a conforming reference to ensure that the school districts are aware that they need to comply with that statutory section that's newly created. Section 3 requires that districts comply with the procedures and the guidelines and standards in accordance with this act not later than July 1st of 2024. Section 4 on page 9, lines 13 through 21 contains the effective dates. Sections 3 and 4 are effective immediately, with the statutory sections effective July 1st of 2024. Subject to your questions, Mr. Chairman.
Last question.
Yes. And Mr. Chairman, the question I've got is going to be on page 2, lines 10 through 19. And let me make clear at the outset that I voted for this language both in Senate Education Committee and when it passed the Senate last year. Mr. Chairman, I very much support it. And I do have a reservation of whether it's within our charge from the Management Council, which is, or needs to be as a separate private bill. That's a different issue, Mr. Chairman. There was a question raised in telling them what's developmentally appropriate and what stage is instruction in this area not developmentally appropriate. There was a question, were we interfering with free speech, and would there be a constitutional issue? And what I want to do is try out an idea and see, because I have trouble with that, saying that we can't do that for constitutional free speech reasons. It seems to me we're charged by the Constitution basically with a responsibility for the school districts and making sure and the schools making sure they're properly managed. We all the time tell the school districts what to teach at what level. Do it through the mechanism of standards set by the state, through the State Board of Education. How is that we do routinely and have to do to manage schools different constitutionally from telling people that we're just not, we don't think before grade 3 or through grade 3 that it's appropriate to teach this particular subject at all, and then it has to be age appropriate afterward. Why isn't that just as constitutionally justified as saying you ought to teach reading in the first 3 grades? It seems to me they're exactly parallel. And it seems to me that I don't see that, given the state's responsibilities for managing the schools, that we're prohibited in any way from doing what this does right here. Am I missing something constitutionally? Is there some court precedent? What leads to that kind of constitutional argument?
Go ahead, Ms. Sidetrack.
Mr. Chairman, Senator Scott, that's a great observation, and I just would like to point out again, the memo, all of LSO's memos, when we draft them, are meant to point out potential constitutional issues. We, of course, don't have an opinion on the constitutionality of a bill, and we're not taking a position on this bill. It's our job to advise you of potential issues that may come up. With regard to your specific question about the First Amendment, it's not necessarily the act of prohibiting or requiring a certain subject matter, but the subject matter that is prohibited, which is discussion of sexual orientation and gender identity. And there is some precedent that in the event that you are chilling the environment that students are being educated in, or you're chilling the environment that educators are educating, that is a violation of the students' First Amendment rights or the teacher's First Amendment rights. And there's lots of cases that discuss that you don't shed your First Amendment rights as soon as you enter a school building, whether you're a teacher or whether you're a student. And so those are the line of cases that we have pointed out. And, whether it falls within, whether sexual orientation and gender identity, whether, it's spoken or unspoken and is within the First Amendment, I can't say for certain, but there are cases, not of our jurisdiction, that do indicate it would be protected speech.
Go ahead, Senator Beitman.
Drafting question. So before we get into the weeds on the constitutional stuff. In the enacting clause, I noticed on line 7, it says prohibiting classroom discussion. That's a specific term of art, but nowhere else in the actual statute proposed does the term discussion come up. It's instruction. And I think instruction is what, I can't speak for Senator Dockstader when he had this original bill drafted last year, but I should have caught it previous to this meeting on that one term discussion. I think it should read instruction, because that way the enacting clause matches the actual proposed statute, because the statute prohibits school districts from instructing. Instruct means to teach, to edify, to indoctrinate, if you look up the term instruct, that's exactly what it means. Discussion is completely more broad, and I think that may be entering into this murky waters of constitutionality. Am I correct?
Mr.
Right.
Chairman, Senator Beitman, certainly we can make that change in the enacting clause.
We'll go first to Representative Lawley and then to Senator Rothfuss.
Thank you, Mr. Chairman. Is it fair to say, Tanya, that the memo done here primarily is directed at page 2, lines 10 through 19 of the bill? Is that a fair statement of the memo? And then I have a
Mr. Chairman, Representative, yes. I mean, what qualifies as classroom instruction, sort of to Senator Beitman's point, there's no definition within statute of what that is. Obviously, there's a provision for the state board to kind of identify what may be appropriate and what may not be appropriate. There were other items, I don't have the drafting folder with me, but there were other items that were sort of ambiguous terms. And it would note, this is not legislation that LSO initially drafted. It came from another state and sort of instructed to resurrect it or draft it as it was enacted in, I think, Florida.
Okay, go ahead, follow up.
So, thank you, Mr. Chairman. I want to talk to you a minute about the Wyoming Constitution, Article 2, Section 24, which says basically a bill is to contain only one subject. And what is your thoughts on whether or not the provision we're talking about, page 2, line 10 through line 19, may run afoul of that particular constitutional requirement, as it is not really about parental rights, it's about classroom instruction, and whether or not it would be better constitutionally to have that piece in a separate bill?
Go ahead, Ms. Heitrick.
Mr. Chairman, Representative, of course, constitutionality first rests with you all to make that determination, and then with the courts. I think the bringer of the bill, and we didn't identify this in the memo, I would note, but I think the bringer of the bill sort of termed this under parental rights under both umbrellas. I can't speak to it directly. Senator Whiteman, I don't know if you have comments to that.
You have comments, Senator Brightman?
Yeah, Mr. Chairman, we did over the phone discuss, breaking this into two bills or one bill, but since they're both in Title 21, I felt comfortable they both deal with parental rights, whether it's what your kid's being exposed to outside of the Department of Education standards, right? Because these are not in the standards. This issue is not in the standards. So if your kid's going to be exposed to that, you should be well aware of that. That's a parental rights issue. As well as the rest of the bill deals with how you're notified and any changes in your student's situation, whether your mental health, physical health, questionnaires, all that stuff. So it's all comprehensive in this one bill. I think we've seen bill drafts, omnibus bill drafts come through this body in a lot worse shape than this, and dealing with multiple titles, not just outside of Title 21, combining different titles, and they pass and they are still law of the land. So
Again,
Follow up?
yes, follow up. Thank you, Mr. Chairman. There seems to be an incongruency, though, concerning, first of all, the notice requirements aren't limited to a certain age group, like third grade and under, or they're really, all of the notice requirements go beyond that as I read the bill. So this section seems to be incongruent in this way, that the parts concerning notification and parental rights are very specific, and I support those fully. This part, a parent could have a different view than what we say in this bill about this. And where does that really run afoul of parental rights? So it's kind of, to me, there's an incongruency of the two concepts, even though statutorily I do understand what you're saying. So again, I just wonder if it isn't, because of that, supports sort of the idea that it might be better in a separate bill. And honestly, because of some of the constitutional issues that swirl just around this section, again, I guess that's where I'm going at, is to really, I really think these other parts of the bill are very important and would like to see us move forward in them. So that's why I raise it, is that there just seems to be a little bit of swirling around that, and maybe move it to another bill, and let's not let it bog down this bill. But that's, again, just a comment, really.
Mr. Chairman, if there's more discussion on this, I'd suggest that the committee stick with this topic.
Okay.
I was going to go back to Senator Scott's note a few minutes ago, but I don't want to keep switching topics, so let's stay here, and I think Senator Brightman has some thoughts.
Chairman Scott, you have a question?
I have a comment on this particular issue.
Okay.
Mr. Chairman, and this was a thought in the Senate last year. And I do have a question for Tanya. I remember seeing an article in one of the legislative magazines that said the courts tended to be much more tolerant on what was two subjects or not in a bill than the legislatures themselves. And I had thought that this was closely enough related so that it would probably stand a court test, Mr. Chairman. But because these subjects are different enough, it may be politically wise to separate them into two separate bills, because it's been my experience over the years, you put them both in the same bill, what you do is you acquire the enemies of each bill and wind up passing neither one. So they may, if you separate them, they are more likely to pass. And that makes some sense, because there are some different considerations for these two. So am I right in thinking that they might well stand a court test, but then the political test is a question we've got to use our judgment on?
Mr. Chairman,
Go ahead.
Chairman Scott, I don't have a response to that. I'm not familiar with the article that you're referring to.
Committee on this section? Go ahead, Representative Provenza.
Thank you, Mr. Chairman. On the section 4, so page 9, looking at when this would be enacted, 2024, knowing that our legislative session would end mid-March, and then it would be, the districts would have to come up with rules. Do you know with our public, our rule promulgation process, if they'd have to meet 3 times, coming up with these rules to then also follow those statutory obligations and then also meet the July 1st deadline?
Mr. Chairman, Representative, I'm sure the School Boards Association can speak to that more eloquently than I can. They could certainly adopt emergency rules, which are effective immediately upon signature, but I don't think that they follow the same processes an administrative agency does.
Go ahead, Representative Brown.
Thank you, Mr. Chairman. Ms. Heitrick, just out of curiosity, and this is more for just my own edification, one of the areas that was kind of glaring to me was the change of the utilization of the notwithstanding for getting rid of the Administrative Procedures Act and putting that, saying that this overrides that. I'm just kind of curious, out of your knowledge, or maybe even anybody from the committee, where we put something like that, just so I have a little bit better understanding why we would go outside the Administrative Procedures Act for any type of an argument in this case. It seems a little strange to me, but I'm also haven't been combing through the green books on a regular basis to find out any other areas that we might be doing the same thing.
Go ahead, Ms. Heitrick.
Mr. Chairman, Representative Brown, I've never researched on what other instances we've not withstood the Administrative Procedures Act, and that really is a policy choice. Perhaps Senator Beitman could respond to it.
Senator Beitman, you have any comments?
I have a guess as to why it's in there. It's probably to ensure a swift and timely resolution of the problem, because in a matter like this, time is of the essence and a resolution needs to happen. School boards need that resolution quickly. We've got a group of really angry parents. They want to see this resolved one way or the other and get a final decision. But that's just a wild guess. I have to defer to the original bill sponsor as to the.
We could ask school boards if that'll work.
And we can ask him if it's doable. Yes, sir.
Go ahead, Senator Rothfuss.
And I don't know if this was in the original state's language and we just copied it over from the original state, or if this is something that was crafted specifically for the state of Wyoming based on our Administrative Procedures Act. Maybe Ms. Heitrick is familiar with whether that was drafted based on copying that language or whether that's specific to Wyoming.
Mr. Chairman,
ahead.
Senator Rothfuss, I did not look at the Florida legislation. The instruction was to resurrect this bill, and we did as we were instructed.
Okay, so this is copied from the previous text, and we don't know whether the previous text was copied from Florida or not.
No, but we can certainly look at that issue, Mr. Chairman. We can certainly look at that issue, Senator Rothfuss, and get a response back by the next meeting.
Okay, and Mr. Chairman, one possible consideration there is we don't know how that state handled alternative pathways to the Administrative Procedures Act, where we allow for court access. I believe at any point, if I'm not mistaken, we don't deny access to court if you want to go that route. So you could have an immediate enjoyment or something along those lines, I believe, or maybe we do. I know Ms. Heitrick's making faces that lead me to believe I'm wrong.
Mr. Chairman, Senator Rothfuss, I was just thinking if there's an exhaustion of remedies requirement,
Okay.
For the school districts, and I'm not certain on that.
Okay, that would be worthwhile knowing.
You'll follow up on that then. Thank you.
Mr. Chairman, if we're done with that, I'd go back to my
Please go back to
earlier
your
thought.
original
All right.
thoughts.
Mr. Chairman, Co-Chairman Scott was inquiring regarding the First Amendment concepts with these first provisions into the A paragraph, and whether we do that all the time. And the example that I think is illustrative is we provide standards that are constructive standards, something along the lines of everyone should be taught that Ronald Reagan was the 40th president of the United States as a constructive standard. It would be very different from a free speech standpoint to say you cannot mention Ronald Reagan in your instruction. And I think there's a clear delineation there from a speech standpoint. And I think it's important to realize that delineation, that freedom of speech, while it can be constructive and destructive, in that circumstance, for us to say as a state, we'd like to make sure everybody understands that he was the 40th president of the United States, is a very different speech issue than you can't mention former President Ronald Reagan. So while I understand you may have concerns that there's a equivalence there, it seems to me that constructive and destructive rights regarding speech and what we say can't be discussed in school versus what we say should be taught in school are two very different concepts. What I'd ask Ms. Heitrek is, do we have any court decisions that you're familiar with that might get into that nuance? I don't know whether, I don't recall that necessarily from the memo, but it seems to me that that's a key delineation that might be something we could look to the courts for.
Go ahead, Ms. Heitrek.
Mr. Chairman, Senator Rothfuss, I'm not aware of any Wyoming Supreme Court cases that would directly answer this question. And the cases that I mentioned previously are actually from other jurisdictions. They're not from the 10th Circuit, and they're not from our Wyoming Supreme Court.
Senator Brightman, go ahead.
I might be able to help. I have a couple up here on my, just browsing the internet. Mayor versus Monroe County Community School, a 2007 U.S. Court of Appeals for the 7th Circuit case from Indiana. An elementary teacher indicated during a classroom discussion on current events that she privately opposed the Iraq War, and she was subsequently terminated. The court held that even though the speech was an issue of public importance and was germane to the classroom discussion, the school could limit that speech because it unduly disrupted the employer's business of education. Per the court, end quote, this is so in part because the school system does not regulate teachers' speech as much as it hires that speech. Then it goes on, there's another case, Brown versus Chicago Board of Education in 2016. Something about a racial epithet in the lyrics to a song. And so there is precedent all over the place for schools being able to tell teachers what they can and cannot say in the classroom and to avoid disruptions of the classroom. So hopefully that answers your question. Obviously, it hasn't been squarely before the Wyoming courts, but I'm sure the other courts, our courts would look at what other courts have done.
Okay, further questions for Ms. Heitrek? Go ahead. Representative Clauston.
Thank you, Mr. Chairman. Mine are really more nitpicky on little things I'd like changed in here, so I'm not sure this is the time to ask or if you want to wait and see how the bill goes, so it's up to you.
Let's see how the bill goes. I think that it's going to go the same route the other one went. We'll work it in November. Anybody else? Anybody else like to ask a question from the committee? Okay, thank you, Ms. Heitrek. We'll move to public comment. Remember, we're going to keep our comments to 5 minutes. I'm the official timer, me and my Verizon phone. And I think that we'll put a different twist on it this time. We'll do those that are against, fill up the 4 chairs against, and then we'll do those that are for, and then we'll do against, then we'll do for, and that way we'll work our way through the crowd in that manner. So 4 against, fill up the chairs. And 5 minutes each, not the set of 4.
Mr. Chairman, did you want to do online at the end again?
Yes.
Okay.
Thank you. Remind me again at the end. 4, fill them up. So we move through it. Yeah, against the bill. Against the bill first. Whenever you're ready.
Mr. Chairman, members of the committee, my name is Grady Hutcherson. I taught 2nd grade in Goshen County for 24 years, and education is near and dear to my heart. And I currently and proudly serve as the president of the Wyoming Education Association. And as we have this discussion, I appreciate that it's already been mentioned about the potential of there being 2 different topics embedded within this bill. My guess and assumption is there are very few people who have been in the 2nd grade classroom providing instruction for 24 years. So I want to share with you a couple of concerns that this bill raises for me as a professional licensed educator teaching at the 2nd grade level. And I'm going to try to illustrate some of my concerns about how my speech is potentially chilled from this legislation with stories that have actually happened in my classroom. I'm going to tell you a story about a student named Frank. That's not his real name, but I need you to understand that he was a boy because the legislation refers to gender identity. And Frank always brought a doll to the classroom, to school every day. And during recess, he played with female students and that doll. I didn't care that he brought a doll. I cared about his safety and him not being bullied by other people. That was my concern. When you work with 20 students who are 7 and 8 year olds, we can talk about what's developmentally appropriate, agreed, but there are many variables that also impact that. If you're a 7-year-old with a sibling who is in high school, you have many different questions than if you are a 7-year-old who's the oldest in your family. So based on this bill, I don't understand if I would be able to have and provide instruction to my entire class about the fact that it's okay for Frank to want to play with dolls and females or not. So that's one story that I share with you that this bill causes me in my mind as an expert working with 7 and 8 year olds. A similar story is simply teaching language arts and writing and the use of pronouns. You can't not talk about gender identity and the use of pronouns and when you use he or she as an example. So this bill becomes very concerning when it comes to practicality in the classroom. And I see some puzzled looks. So I'm turning to all of you to answer the question, for example, would I be able to have that discussion with my class about Frank and the doll? I continue to see puzzled looks. I see some people shaking their heads no.
I would just suggest that it depends on is it age appropriate, number one. What are you going to explain to the kids about Frank and his doll? If it's simply Frank likes this doll and that's okay, that's not a problem. What we're talking about is far beyond that. It's instruction into gender identity politics and this whole culture war we're in now. It's like it or not, we're in it. Wyoming's not immune to it. It's coming here, if it's here already or not.
Mr. Chairman, Senator Whiteman, thank you. That's my whole point. Within this bill and that language, it's open to different interpretations and different people's views and opinions about a topic. So hence, there would need to be more specific language included so that I, as a classroom teacher, would know what I can and cannot say or do when it comes to those topics. Just a couple of other items, if I may. Back at the end of May, Joint Education Committee met and had a phenomenal meeting with experts and stakeholders across agencies regarding the mental health needs of our students. And it's not on the agenda today, and now we're talking about this bill. And that's hugely concerning to me. I'll pose one more question to all of you, and then I'll stop talking because you're probably already tired of listening to me. I don't understand what this bill achieves that parents don't already have as a right in our school district. So from your perspective, what additional rights for parents does this draft bill from Florida provide to parents that they currently don't have? And with that, I'd love to hear a response as well as I would stand for questions. Thank you for your time. And please know that I appreciate your work and dedication to education. Thank you.
Go ahead, Senator or Representative Claus.
Thank you. Thank you. I guess my question would be, currently, if you as a second grade teacher bring up a subject that a parent isn't comfortable with, what is the procedure? They would talk to you, go to the principal, go to the school board? What's the local control there? And how would it be handled at your school?
Go ahead, Grady.
Thank you, Mr. Chair, Representative Clouston. Ideally, that parent would come to the classroom and have a conversation with me about any concerns that exist. Oftentimes, that step can be skipped, and a parent, and understandably so, a parent will go straight to the principal. Ideally, then that principal would bring me into the conversation, because please keep in mind there are always two parts to every story. So a version of the story that a 7-year-old takes home to share with parents may certainly be different than the version of the story that I share. And so I would want to be involved with that conversation with parents and or the administration as we move forward to rectify, the problem and the concern, because ultimately, as a classroom teacher, I want to have strong relationships with my students, but equally so with their families, so that we can all put the needs of the students first and foremost to help them grow and succeed. Thank you. So that answers your question.
Senator Rothfuss, go ahead.
Thanks, Mr. Chairman. I wanted to follow up on that. In your experience with those parents, did they have a diversity of viewpoints that might relate to this issue?
Go ahead, Grady.
Mr. Chairman, Senator Rothfuss, thank you for the question. I think that's always the case. I was raised in a very traditional, old-fashioned family, and I use terms like ladies and gentlemen. And that is attached to somebody's gender identity. Mm-hmm. So there are people who have differing views. I think what it boils down to, by and large, 99% of the time, is that conversation where I can visit with parents to explain all of the details of what transpired to help them understand what I said, even if they may disagree with it or would have preferred that I approached it and handled it differently. Having that conversation, even when there are differing views, I think goes a long way. And then it also provides me an opportunity to be more reactive and to keep in mind the wishes of that parent who may have some entirely different views than I do. So I'm not sure if that answered your question entirely.
And Mr. Chairman, following up on that,
Go ahead, follow up.
the bulk of this legislation is intended to expand parents' choice and their ability to have unique viewpoints and differentiate those viewpoints based on their own specific approach to raising their children. And what I'm hearing from you is that is certainly consistent with your observation that there are diversity of viewpoints among those parents with regard to sexual orientation and gender identity, and that different parents might have different interests in how those topics were expressed and addressed in the classroom, which in my interpretation then is contrary to the student choice part, or excuse me, the parent choice part of the legislation. Would you feel then that this A paragraph would limit your ability to address parental choice as it relates specifically to sexual orientation and gender identity?
Mr. Chairman, Senator Rothfuss, thank you. I do believe that paragraph creates that chilling effect and that element of unknown as to whether or not I can or can't say certain things. And I feel like I'm probably not accurately answering your question, but correct me if need be. If I have parents who are who have opposing viewpoints on gender and issues, I can't make everyone happy. So there is a chance that in an effort to have parents who are very supportive and maybe open-minded to a more broad interpretation of gender identity, I can't meet their needs and at the same time meet the needs of the families who have students in my classroom who maybe have much more narrow viewpoints on that topic. So it puts me in a position of now I don't know what I can do. And I think that's what you were getting at, but thank you, Senator and Chairman.
Any other questions? One more from Senator Beitman.
Thank you, Mr. Chairman. Mr. Hutcherson, so back to your example that you gave, other than protecting the child from bullying, which is absolutely your job, right? If it's a second grader being bullied because he is playing with a doll, you can stop the bullying and tell those kids that we respect everybody in this classroom. Bullying's not tolerated. We love each other for who we are, period, and end it at that. That's what this bill is aimed at, is stopping the discussion from happening from kindergarten through third grade, because these kids can't even wrap their heads around what the heck you're even talking about, and it prevents an act like some teacher who's a very big-time activist, say, from going on a diatribe for 10 minutes about whatever issue they want to talk about, and using that as an opening, and then going off and giving their opinion that maybe gender is just a social construct and there's no such thing as binary, and then going off the charts. And then you've got into the problem where you've got two different competing interests there. Why not just get back to educating, reading and writing, and telling the kids to quit eating their boogers in kindergarten and not talking about gender identity?
Mr. Chairman, Senator Beitman, if I may answer your question with another story that's probably a better example. As a second grade teacher who was in the classroom for 24 years, working with 7 and 8-year-olds, it's not that simple. And I have worked with students who have only ever had female teachers, and they come to my classroom and they begin second grade and they call me Mrs. Hutcherson. So I think based on your question, we wouldn't address that, and I would just let them continue to keep calling me Mrs. Hutcherson, because I wouldn't be able to provide any instruction to the students. How about the title Mr. is for males, and Mrs. or Mrs. is the title for females, depending on marital status. So the story about this, Frank, I understand where you're going. The story with having to teach more has many other applications that complicate the matter. So it's not that cut and dried and that simple. And I can't read whether or not you like that response. But I can tell you I've worked with 7 and 8-year-olds for 24 years. So please take that into consideration when you're thinking about how to decide from your chairs what's best for 7 and 8-year-olds. Thank you.
Any other questions? Thank you, Grady. We had you on the hot spot for quite a while. Thank you. Who's next?
Hi, Kenvi. Good afternoon, Mr. Chair. My name is Rachel Berkness. I'm an attorney here in Cheyenne. I represent individuals who've been unfairly hurt, including members of the LGBTQ community throughout Wyoming. I've reviewed the memorandum by the Legislative Service Office, and rather than reiterating the host of concerns, constitutional concerns that arise with this bill, I think there's something that hasn't been addressed that should be pointed out. And that is, not only are content-based speech restrictions required to be narrowly tailored to advance a compelling government interest, but if they are applied in a viewpoint-based manner, that is going to be per se unconstitutional. So the legitimate government interest, the compelling government interest that's required in order for a law like this to be held constitutional or to survive a constitutional challenge has to be something that is not no such thing as binary, because that is viewpoint-based. It has to be something that is content-based, and even then, there is a tremendous hurdle to overcome for this type of a bill to pass constitutional muster, and that is specifically tailored or narrowly tailored to a specific government interest that is compelling. The compelling interest cannot be an attempt to dissuade children from being homosexual or transgender. The United States Supreme Court recently held in the Bostock decision, through the opinion of Justice Gorsuch, that discrimination based on transgender status or gay, lesbian status is discrimination based on sex. So the state will have to overcome a mountain of evidence in order to support this law, should it pass. One example that I think is interesting is that in Florida, the law immediately faced challenges not based on its enforcement, but based on its existence, which means that plaintiffs' attorneys, like myself, jumped on the opportunity to sue the state based on the mere existence of the law and were then shut down. That still takes state resources to defend against, even if a motion to dismiss is successful. So I think on both sides of the coin, there will be an opportunity for lawyers both challenging an educator's behavior or challenging the existence of this law and its enforcement either against a teacher or the behavior of a student to bring claims that would hurt the financial interests of the state. Another thing that I wanted to address in the few moments that I have is that there's already been United States Supreme Court precedent in favor of parents' rights, but it went the other way. And it's really long established, well-established precedent from 1923. And in that case, it's called Meyer v. Nebraska. In that case, a school district was prohibited from teaching German. And the United States Supreme Court held that prohibiting educators from teaching German violated parents' rights over the education of their children. And this is not business as usual. If it were business as usual, you would see lawyers like myself bringing claims immediately anytime that there's a decision not to teach trigonometry to first graders, for example. But the reason that this is not is because it is facially content-based, which is very rare. And so there is a presumption that it is unconstitutional. And an opportunity like that does not arise very often for individuals like me who pursue violations of people's rights in the state of Wyoming.
Thank you, Mr. Chairman. Ms. Berkness, correct? I'm wondering, we talked about the vagueness and the constitutionality of not having a clear enough statute, and I'm wondering if you could provide an example, in this case, what that would look like. So if we were to try and meet that constitutional obligation, how thick of a bill we would have.
Go ahead, please.
Mr. Chair, thank you, and Representative Provenza. I appreciate that question. I'm not an educator, but a lot of the examples that I've heard from other people, including the gentleman who spoke right before me, highlight what it means to apply this law in a viewpoint neutral way, such as using the term Mr. or Mrs. to address a teacher. If there is an LGBTQ teacher in the state who uses pronouns that might not align with what they were assigned at birth, and that teacher is challenged in the use of those pronouns, but all the other teachers who use the same pronouns that they were assigned at birth are not, that is viewpoint based, and that is unconstitutional, and that is a slam dunk for a person like me.
Senator Rothfuss.
Thank you, Mr. Chairman. Senator Beitman referenced Mayer versus Monroe County, which is out of the Seventh Circuit. And that language was, as I understand it, I pulled up the decision, it was specifically the teacher as an individual, their viewpoint was expressed, and that was the fireable offense because they were advocating for a specific side, so to speak. It's my understanding, based on what you're saying, that this legislation effectively does the opposite, and that case cited may even support it, because it's the idea that when you take bias or take a biased position, whether you're that teacher or whether you're the state, that at that point you're beholden to strict scrutiny to have a compelling state interest to take that bias. Is that accurate?
Go ahead.
Mr. Chair, thank you. Senator Rothfuss, thank you. I think the use of the term bias is maybe not correct. It just has to be viewpoint based.
Okay.
So I think the same teacher in that circumstance could have said, I support the Iraq war.
Yeah.
There is a couple of limited restrictions that are permissible under the Constitution on teachers' free speech in the public school context. One of those is speech that substantially and materially interferes with school activities, and I believe that that is exactly the language that was used in that case, it is a narrow exception. And as an individual who would bring a case on behalf of an LGBTQ teacher or a member of an LGBTQ family, I would be much more comfortable on the side of presumptively unconstitutional law that, if applied in a viewpoint-based manner, is absolutely unconstitutional. There is no way to walk that tightrope. Then I would be on the other side of the courtroom saying, well, there's a narrow exception for substantially and materially interfering with school activities.
That's so. And Mr. Chairman, one more follow-up.
Follow up.
We had a discussion, I think you were here for it a few minutes ago, about the idea of our state constructs standards, education standards, and consideration of those standards and the fact that we determine those standards by the state. And then the idea of saying you cannot teach something. Can you provide some delineation between those two that show why this may be a violation of First Amendment rights, while our construction of standards would not necessarily be, or perhaps instances where it would be a violation of First Amendment rights, so that we have more insight?
Please go ahead.
Thank you, Mr. Chair. Thank you, Senator Rothfuss. I can provide some examples of how I think that would work. First of all, for example, in the teaching of math curriculum, that is not a content-based question. And so what levels of math instruction are appropriate for a first grader versus what levels of math instruction are appropriate for an 11th grader is not content-based, so it's not subject to the same level of strict scrutiny that is presumably unconstitutional. Again, presumably unconstitutional is rare, and it is often a slam dunk. When that standard applies, in order to carry that massive burden, the state has to show that their regulation is narrowly tailored to a compelling government interest. And the state, in those circumstances, if that type of legislation is challenged or that type of regulation is challenged, can much more easily show that there is a compelling state interest to teach little kids the baby steps before getting up to trigonometry. It is a much, much, much higher burden for the state to show that there is a legitimate interest in what the Supreme Court, through Justice Gorsuch, had said is sex-based discrimination, which is discrimination against GLBT individuals or transgender individuals. That is going to be a very high, high burden that, if I were at the Attorney General's office, I would not like to try to meet.
Standards, I mean, looking through K through 2 right now, I mean, there's nothing in our standards that talk about any sexual orientation, sexual identity. Have we seen any cases in Wyoming where this has been brought up, that people are complaining that these standards are being taught?
Mr. Chair, thank you. Thank you, Representative Clausen. I am not aware of any challenges to any existing curriculum out there, but the wording in this bill is no school district shall permit classroom instruction by teachers or any other person on sexual orientation and gender identity. The term sexual orientation and gender identity have been challenged in Florida for their constitutional vagueness, and that has been addressed in the Wyoming Legislative Service Office's memorandum on this topic. My view would be that it is probably not unlikely for a person to challenge any instruction as to gender identity or sexual orientation whatsoever, including, my name is Miss Berkness, and I am a lawyer here on Wyoming Constitution Day, teaching you about what it means to be a lawyer like myself. The term Miss Berkness is a gender identity. That is a pronoun that I am using. And so unless that is applied across the board, where we're all just saying, my name is Berkness, or my name is Clauston, that is a viewpoint-based way to interpret that law that I do not believe is going to survive constitutional muster. So it's broader, it can be applied much more broadly based on this language than any examples that I'm aware of in instruction in Wyoming currently. And that is why there's a constitutional vagueness concern raised, I believe, in the LSO's memorandum.
Thank you, Mr. Chairman. Thank you for being here. Question on standards here, as far as maybe some challenges being brought up. Who is developing those standards? Is it the legislature? Is there public input to develop these standards? And maybe that question is for the Department of Ed, but I just want everybody to know who's developing the standards for public education.
Mr. Chair, it's Berkness. Thank you, Mr. Chair. And thank you, Representative Berger. I do believe that that is largely outside of my area of expertise. However, as to the subsection that deals with students over the age of third grade, where the standard is, I believe it's whether a reasonable, prudent person would find the subject to be age appropriate, is either that language is either in that subsection or in the subsection about whether or not it's permissible to withhold information from parents. I'll say the reasonable, prudent person standard is a standard that comes from the law. It is a standard that you often need a jury of 12 to determine, and juries can go one way or the other. It's hotly debated. That is not something that provides a clean line, bright line rule for individuals such as educators to follow.
Thank you very much. It was good knowledge.
Thank you, Mr. Chairman.
Okay, next.
Mr. Chairman, members of the committee, Tate Mullen, Government Relations Director for the Wyoming Education Association. I want to reiterate one of the points that was raised in regards to pronouns in literacy, the idea that this will have a chilling effect in the classroom. This is a component of literacy in K through 3 that is incredibly important. And to President Hutcherson's point and Rachel's point, the idea of being able to discuss those pronouns in the context of literacy raises that question. Am I overstepping my bounds? Am I doing something that this law might be perceived either by a parent or by somebody else as violating this law? It will have that chilling effect. Some of the other things that we need to think about in terms of context of the classroom. So you have in second grade, read alouds or classroom libraries are a great big part of what happens in second grade, right? And having a wide variety of classroom materials is important because students need to take an active role in their education. And not only an active role in their education, but they need to see themselves in their education materials. There's a couple of books out there that are within that age range. Misadventures of the Family Fletcher, Honey Leon, Take the High Road, right? Like they're within that age range. They do not discuss specifically gender or sexuality, but one of the books has two fathers. It's kind of a Bernstein Family Bears, right? They go on adventures. It's not a discussion about sexuality or gender identity, but because that book might be in a teacher's library, does he then violate this law? That's the vagueness. That's the question. That's the First Amendment part to this. Now, if the answer to that is, we can talk about gender identity as long as it's cis straight or as long as we're not going into discussions about homosexuality or transgender. That's where it becomes the discriminatory 14th Amendment issue. Leaving that aside, one of the other things I urge you all to take a peek at our health standards. Our health standards are developed by the State Board of Education with significant public input, as with every other one of our standards. If you have questions in terms of this is a skills-based approach for students, we do not discuss sexuality, and it is not in here until the 8th grade and the 12th grade. If you would like, I urge you to ask questions about what that looks like in context. I want to respect time and move on, though. The second part of the bill, and this is a second part, I do believe that this bill violates the rule of single subject. But the second part of the bill, discussing parental rights, there are some significant concerns here. I appreciate everybody's intent in keeping our students safe and engaging parents. That's absolutely paramount to a student's success. However, we do have some unintended consequences. Within our school districts, a significant amount of neglect and abuse cases are first detected within those health screenings, within those screenings that we conduct at our school districts. I'm curious as to what you think a neglectful or an abusive parent would do if they were given the opportunity to opt out of that screening that is the very thing that catches most of them. It is a significant problem and puts students across the state of Wyoming at risk. Secondly, the change in notification. So in terms of mental, and we've got some folks in the room who can speak to what mental health services look like and the importance of trust in those communications and seeking out somebody for mental health. Students just don't roll up to a counselor and say, hey, I'm being abused. It's a very sensitive conversation that it's a lot of feelers out there. I need to make sure that I feel safe with this person. I need to make sure that I can trust them. So for a student who may be being abused at home or maybe being neglected, or maybe there's spousal abuse at home, and that's what they're experiencing, and they need to talk to somebody, that change of services then to that parental notification sends that signal to that abusive parent or that neglectful parent. And it is a red flag for them. Again, putting students at risk. I do respect the initiative that we need to get parents involved. And I agree, we do. And I think that there are ways that we can do it.
4:30.
I think that there are policy options such as paid family leave. There are programs throughout the United States that bolster parenting education, that bolster parent engagement in those students and parents' access to classrooms. Those are the routes that we need to take, not bills like this. Thank you.
Thank you, Tate. Questions? Go ahead, Representative Berger.
Thanks, Mr. Chairman. Tate, Mr. Mullen, thank you for being here. I'm a teacher, and I teach 1% special ed kids, and my pronoun is Mr., and it's used Mr. very often. If this bill is passed, and it happens to me daily by a few students who cannot get the Mr. correct, and I'm Mrs. Berger, and I'm using this as me, and I'm putting myself out there, and I know it's probably very common in some of our lower grades that pronoun is misused. If I redirect, if this bill is passed, if I redirect and change that gender identity, could I be sued as a teacher? With this bill being passed, can I be sued because I redirected that child to say, I am Mr. Berger, not Mrs.?
Mr. Chairman, Representative Berger, that is the risk of this bill.
Thank you, Chairman. Honorable members of the committee. My name is Jordan Evans. I'm a father of a fourth grader, and I'm also attended all of my school here in Wyoming schools, and I'm also the current chair of the Laramie County Democratic Party. I'd really like to bring the focus to the local level and to the matter of local control specifically. The role of the Wyoming legislature in education is primarily to set educational standards and to disperse funding to school districts. The role of setting curriculum and managing classroom policy is rightly the purview of local school boards who are elected and accountable to their communities. This bill would subvert the authority and the autonomy of local school boards and interfere with their ability to address the needs and concerns of their staff, students, and parents. In short, what is right for a district in, say, like Sheridan County or Natrona County may be different than what is right in Laramie County or Albany County. And each district should be able to make that determination on their own. In fact, in Laramie County, we are in the middle of a public debate that is also about parental rights. Laramie County School District 1 is considering adopting a policy that would define sexually explicit for the purposes of administrating library policy and potentially later on for classroom policy. Citizens with diverse and strong opinions have been filling school board meetings to speak both in favor and against this proposed policy change. I can assure you, if you want to watch the recordings of these proceedings, that you will see that the issue is far from settled here in our community. But the process is working. The debate is happening where it should be, which is in front of the governing body closest to the issue and closest to the people. In other states where laws like this have gone into effect and are being actively challenged in court, this law has forced the removal of many of the texts that are at the center of our local debate from school libraries, regardless of the feelings of the local elected officials. Local control is how Wyoming deals with other education issues of supposed safety and academic concerns. Local school boards choose whether or not to allow teachers to arm themselves. Local boards are the only level where individual teachers are held to account for student performance, and these are issues that this committee has considered in the recent past and elected to leave to local control. So why now should this issue be any different? Therefore, I urge you not to advance any further down this road and respect the rights and responsibilities of our local school boards, our students, and per the relevant LSO memo, our constitutions, and thank you for your time and attention.
Go ahead, Senator, I'm sorry, Chairman Scott.
You mentioned that you thought the state role was funding and setting of standards. I'm going to suggest to you and want your reaction. Does the state not also have a role in seeing that the instruction in the schools is effective and that it's something that the students are learning the things that they need to? It seems to me that as I look to my responsibility to my constituents, getting results from the school system is perhaps paramount.
Thank you, Chairman, through yourself, or I'm not sure which chairman I should go through, but thank you, Chairman Scott. Yes, I would agree that that is a responsibility. And in fact, that is the purpose of standards, because what good is a standard if you can't measure against it, which is why we have standardized testing. Absolutely.
Further questions? Thank you. All right, like people that are for it. Hi, Nathan. How are you doing?
I'm doing well, Mr. Chairman.
You want to start this off?
Yes, sir. That would be good.
Great.
Thank you, Mr. Chairman, committee. My name is Nathan Winters, president of the Wyoming Family Alliance, and I came with the original intention of discussing the bill much deeper than I intend to now. I am on and for the bill. I believe in it very strongly, but it has also just over the last week or so become apparent to us that there are others that are trying to use our name, Wyoming Family Alliance, to say something that is 180 degrees different from where Wyoming Family Alliance, the Wyoming Family Alliance, the official one with both at the state level and the federal level, where we stand. And so I wanted to come up here first and foremost in my role as president of this organization to let you know that the thousands of families that we represent are for this bill. And there may be others that try to misuse our name for their intention, but I just wanted to make you aware that that is not us. We are for this bill. Thank you, Mr. Chairman.
Good job. All right, next.
Good afternoon, Mr. Chairman, co-chairman, and members of the committee. My name is Lorraine Wilcox, and I am a parent of 2 students in LCSD1 currently. I just wanted to come up and briefly, before that, say that I am in favor of this bill. I wanted to give a brief description of an incident that happened with me and my child. This, of course, was above the 3rd grade, so I want to get that out right now, so that if there was any questions on that. However, she was in a classroom in which questions were asked as to whether or not when the moment was she knew she was a girl, when she knew others were boys, and when she said that she just didn't want to participate in the discussion, she was asked to leave the classroom after being instructed. It was because she didn't feel safe. We were also, there was many lies that went around the media. There was certain groups that came out and said that because my daughter simply stated that she just didn't want to discuss the topic, which is her right as well, that other groups felt fearful. I only bring up this situation because I can only imagine how children K through third would feel. We are talking about children who are still learning to tie their shoes, trying to figure out what the color blue is, just wanting to play on a merry-go-round. So this is why I sit in front of you today and I stand for this bill. I also would like to suggest an amendment to the drafted bill on page 2, line 15. It should be K through 6, the number 6 in parentheses instead of K through 3. Thank you.
Thank you, Mr. Chairman. Thank you, Ms. Wilcox. What grade specifically was it? Was it above 8th grade, below 8th grade?
Mr. Chairman and Senator Pittman, yes, it was in high school.
Okay. Thanks.
My name is Mary Schmidt. I am a parent, as I said earlier, but I am also a current elected school board official. As far as whether, I think the question that you guys posted earlier regards to whether a school board could get a policy together. Yes, I have one drafted. It was presented in our policy committee and we debated it this past spring. We still have more work to do on it, but it is a policy that is hopefully something that we can work on and draft and get ready. That does contain several of the things in this bill. So yes, it is something that can be done. It truly is the will of the school board. Do we have the will of the school boards? Probably not all of them, but it is up to us, and we can ultimately do it within a certain amount of time. Now, as far as the memorandum goes with the bill, I'm kind of confused on some of these issues. It says that a government entity may impose reasonable restrictions on the time, place, or manner of protected speech, provided that the restrictions are justified without reference to the content of regulated speech, that they are narrowly tailored to a significant governmental interest, and that they leave open ample alternative channels for communication of the information. I think saying developmentally appropriate conversation with a student is very narrowly tailored. Secondly, open communications of information. Well, I don't understand why talking with a parent is so difficult. That's opening the communications. So I don't understand how that would be an issue for this law. Secondly, in the next paragraph, it gives the example of chilling students, school personnel, and others from disclosing their sexual orientation or gender identity. Why would a teacher or personnel be talking to a child of this age about their sexual orientation? That right there is questionable behavior. Secondly, chilling student, or they give the example. I don't understand where this example applies because it's not mentioned in this bill. So I'm not quite sure what the reasoning for that in the memorandum. Under the due process concerns, it may not provide sufficient notice of what instruction is prohibited. On page 4, line 8 through 10, it talks about the time frame that it has to be before the school year for that notice to be given. So every time I go to get my kids ready for school, there's a list of forms I have to go through, and they're telling me all of it. One of them happened to be the Wyoming High School Athletic Association bill that is in violation of the sports law. I've notified them of that, but I was notified of it before because I had to read it in the handbook. I read it, I wrote my letter, and attached it to my children's athletic form so that they knew I disagreed and I would not follow the Wyoming High School Athletic Association's rules because it's in direct violation of the law that took effect July 1st. Why can we not notify parents that you have these subject matters, these curriculums that are going to be taught? It's not a hard thing to do. Equal protection, essentially a direction that all persons similarly situated should be treated alike. I agree. Every child should be treated like a child at its proper developmental phase. So teaching a child in the situation that was given earlier, you just simply tell you don't bully a child for any reason. You don't address it any deeper than that. And as far as the pronouns go, when a child K through 3 only looks at life through the black and white lens of a young child,
If you say, I'm Mr., they go with it. That's what you're teaching them. We don't guide them to say, you can say Mrs. or you can say Mr. You go by that. And if a child looks at you and says, you are a boy because that's how I see life at that age, and you say, no, you need to call me by a Mrs., an incorrect use of the pronoun, now you are compelling speech from a child. That's a violation of their freedom, their First Amendment, because it can go both ways, and you can't do that. A distinction that involves a classification based on sex is subject to intermediate level of scrutiny, and the distinction can be sustained only if it is substantially related to an important governmental object. The opponents to this bill are saying that we have to classify people. The person who spoke about earlier that spoke about the story of the little boy with the doll, was he classifying that little boy into a transgendered or homosexual? No, you can't do that. You have to just assume that's the kid's doll. And you say you can't bully him because he has a doll. This law is stating that and clearly saying you can't imply that the child is of any classification. You just have to treat them as they are at the developmental level that they are at. So I don't think this memorandum really holds a lot of water against the bill. Thank you.
Thank you, Mr. Chairman, and thank you for being here. In your school district and on your school board, when we talk about a parent that has an issue with their teacher or what's being instructed, what would you say what would your advice be to that parent to do first when they have an issue with their child, or their child has an issue within the classroom with their teacher? What would you say to do first?
Go ahead, Mary.
First, I have to state, I'm an elected school board official, but I do not speak on behalf of the school district I am elected to or that board. But as a person, if someone came to me, I would recommend that if they have an issue with the school, that they first go to the teacher, perhaps depending on the degree of the issue, or the principal, and work your way through the school system, because there are systems in place to appeal and to share your grievances. And I would always say go that route first. Why blow up an issue?
Thank you.
Yep.
Thank you.
Senator Office.
Thank you, Mr. Chairman. Ms. Schmidt, as a school board member, you noted that you have the capacity to work through your process to come up with something that which may or may not be similar to this legislation, but support the legislation. I guess the question I have is, if the legislation did exactly the opposite of the policy you favor, because as you noted, some school districts will probably come down differently. Mine might be different from yours. Would you be as comfortable with a statewide one-size-fits-all solution that is forced upon LCSD 1 that you disagree with and don't have the capacity to work on? Or in that instance, would you prefer that your local school board have its own autonomy and you as an elected school board member get to weigh in? So in other words, do you always want us to have the choice, or just kind of when it agrees with what you like?
Of course, I would always like the choice, but as a school board, I realize we don't have a lot of choices in it. We have to provide all the mental health that you guys budget and statutorily tell us to do. We have to provide certain curriculums by the standards that come from the Department of Education. We don't get to determine a lot of that. I would love to see our school district create an entire curriculum on its own, because most of our teachers spend hours upon hours doing exactly that. And yet we're told no, because we have to go by certain standards and certain regulations that all come from the Department of Education, which is funded and directed by you. So yes, I would love the ultimate control. I would love the check written to us, and then we do what we want with it from completely through. But we don't have that opportunity. We are very restricted in what we can do. Will this law help draft a policy? Yes, it will. Do I have the support of this policy on my board? No, not at the current time. Do I have the support in the community? I think I do. But the point is that this is a generic enough bill that helps give direction to a school board to make a specific, more specific policy. And it will be up to the entities, the school districts, to decide how well they're going to follow it. Much like the Wyoming High School Athletic Association, apparently, they can or cannot follow a law. because it's in their documents in their handbook. So
Thank you.
You bet. Further questions? Thank you very much.
thank you.
Go ahead, ma'am.
Thank you, Mr. Chairman. My name is Ann Lucas. I live in Laramie County. I am a private citizen. I'm not an attorney. I don't work for a trade association. I'm a parent, a grandparent, a voter, and I'm a taxpayer. I am incredulous as a parent and a grandparent that we must consider requiring schools to tell parents information about their children's health, mental health, behavioral condition. We must do this apparently, though, because not all of our schools are doing that. I want to speak just a couple of brief remarks about the legislation proposal itself. There is an exemption that teachers would not be required to, or the school would not be required to contact the parent in the event that there's a suspected abuse situation. If they feel that the child would be in danger, I suppose, then they wouldn't want to add gas to that fire. My question, though, or my concern is, do we not already have requirements for teachers and school administrators to report strong suspicions of abuse to law enforcement, to the Department of Family Services? I suspect we do. And so if there is a suspicion of abuse already, why has that not been reported? And I suspect it hasn't. That's just my question. I read things very literally. Free speech concern. I am concerned that we would view the free speech of a teacher who is a government employee there by choice over a parent's right to know what's happening with their child and their ability to control what the child is exposed to. I see here a lot of opt out. You can opt your kid out of this, you can opt your kid out of that. Why don't we have opt in? Why do we have to choose to remove something rather than, here are our choices, parent, choose what you want your child to be exposed to, because parent, you are in charge of your child. Lastly, I'd just like to remind you that government's job is to protect citizens' rights. It is not your job to protect the government's rights. Thank you. I would stand for questions.
Thank you very much.
Thank you.
You bet. Now I need 4 against. Four. We're at 3. There we go. Okay. Why don't you go ahead and start? Okay. Go ahead and start if you would, sir.
Hi, my chairman and committee, thank you very much for having me today. My name is Ryan McKenzie. I'm an educator in the local school district, and I'm a proud military spouse. My husband is in the military, currently with the U.S. Air Force, but I do not represent my district nor the military. I am speaking on behalf of my own views. And that is that when we got orders to F.E. Warren in Wyoming, we were thrilled. We had several choices, and we were very excited when we got Wyoming because Wyoming has a fantastic reputation for education. You have high standards for kids, you treat teachers well, and there is a very strong school community collaboration. And the past few years that we've been here, it has been a joy to work here. I always tell people it's been my favorite place to teach, and that is true. However, I believe that the legislation that's currently before this committee right now would fix something that is not broken. Wyoming education is not broken. This is a copy and paste Florida law, which is marketed as a parental rights law, but in fact would chill the opportunity for parents, educators, and administrators to work on problems together to solve complicated issues that are confronting our kids at this time. It takes options away. So I'm going to outline 3 hypotheticals, 3 things that have actually happened in my career that I believe that this law would not allow me to do in the future. If a kid comes up to me and is being bullied because his two dads are gay, for the reading of this bill, I would not be allowed to convene a classroom meeting to solve this problem. Even if it was in line with the counseling and the social emotional standards set forth by our school board of education, it would not allow me to do that. Number two, many members of our military identify as either transgender or non-binary. If I have a kid who comes up to me and they want to recognize their parent in our school Veterans Day assembly, this law would not allow me to do that. And then finally, finally, this is a situation that happened to me this past May. I had a parent out me to one of my kids. If a kid comes up to me and they ask me about this situation, would I be allowed to tell the truth? Would I have to say no and lie? Or would I be forced to deflect? Wyoming is a fantastic place to be an educator, and I want it to stay that way. And so I urge all the members on the committee and the chairman to vote no on this bill.
Thank you, and thank you, Mr. McKenzie, for being here, providing testimony. When you speak to your class, do you refer to your husband at any point?
I don't. I usually use the word spouse. I believe that I have a professional relationship with my kids, and having that arm's distance has been something that I have felt very importantly throughout my career. I've been teaching for 8 years now. I will tell you though, there are I have colleagues and other teachers, they invite their husband, and when they get married, they have a wedding party, they have an anniversary. And something about this bill that makes some kind of tweaks in my head is, okay, if I were to do the same thing, would I be allowed to do that? Or would I be taken to the school board?
Yeah.
Or lose my license,
Thank you, Mr. McKenzie. That was my exact concern, is I was wondering if your colleagues held to the same standard frequently, and if anyone cared that they did. And my guess is that they probably don't care when.
I talk about my husband to my colleagues and to my administration. We go to parties, he comes over for lunch, but I always believe in having a arm's length distance with my kids.
Great, thank you.
Thanks, Mr. Chairman. Thanks for being here today, sir.
Thanks.
As a professional teacher, do you feel that that parents can't come up to you and speak openly and honestly about your spouse and maybe present and ask concerns about their child in your classroom or anything? Do you feel that maybe you could be restricting that parental what do I want to say, that parental empowerment, I guess, if I want to say.
No, absolutely.
Do you think they have the right to do that?
Yeah, absolutely. And I've always been very honest with all of my parents about my background, but I use gender neutral terms. I refer to him as my spouse, and it has never become a problem. I think, there's kind of, a hint, I'll give a hint and they'll pick up the hint sometimes, but that's never been an issue in my professional career. This past May, that situation that I was regarding, that's the first time it's even been mentioned to me.
Thank you, Mr. Chairman. I appreciate you being here. Appreciate you taking time off work, coming in here. I do have a question about something that you said, and if you can help me, because in all honesty, I don't know where I land on this bill. I've been asked by every single person on this committee probably, and every person that I know out here in the area here. But you said you would not be able to convene a classroom setting if a kid was being bullied for his parents being two gay men.
Right.
Sorry. Yeah. So I'm looking here at the bill, and I see that it says we should not allow or permit classroom instruction by teachers or any other person on sexual orientation or gender identity. That's instruction. That's having something in my mind that I see as we're actually having a classroom discussion on, and we're actually instructing on. Having a classroom discussion about bullying goes down a different path, in my opinion. Can you explain to me how you're interpreting this, that what you interpret is this is now being told to you cannot intervene in a bullying case?
Sure. Thank you. I appreciate that. I believe as teachers, we're expected to create a harassment-free environment. We're expected to have classroom communications and procedures. We're expected to have routines that align with how we're expected to run our classrooms. And while there are some instances in which there are counseling and SEL standards, social emotional learning standards that we have to follow that help prevent that bullying, as far as it goes, there's never really an instance in which we are talking about sexual orientation and gender identity when it's outside of that instruction environment. So I think there was a conversation that was going on in the debate before we began that public forum about the words versus instruction versus discussion. And so when I originally created my talking points, it was because there was a little bit of a muddy water. But I would say that, most of what this bill has a problem with are things that don't come up in instruction. It's things that would come up during a classroom discussion. And so as an educator, I would want clarity to say, okay, what am I supposed to teach instructionally versus this kid is getting bullied because they have two dads. What am I allowed to say in a classroom discussion? That's not clear. And so I'd like some clarity from that.
Mr. Chairman, members of the committee, my name is Dylan Ford, and I'm a teacher here in Cheyenne. Before I introduce myself, I just want to say thanks for holding this on not a school day when my school's in session, because I really hate sub-planning, so thank you for that. So, like I said, my name is Dylan. I was born in Laramie. I grew up in Rollins. I got married in Saratoga. I married a guy from Rock Springs, so if you have your I-80 corridor bingo sheet, that's my entire life. But I feel like I have to bring up my Wyoming credentials because it's very easy to imagine that all gay people come from exotic places like California or New York, but in reality, we have just as many LGBT adults who grew up here as LGBT kids. And it's for that reason that I would ask the board to strike this bill. When a bill for education comes before legislators, the first test it should pass is, does it help kids? And before we look into the constitutionality of it, before we look into budgeting, redundancies, unforeseen problems, an education bill must demonstrate that it helps students. And it's this first and most important question that it fails the hardest. So why does it not help kids? I'm going to focus on 5 major reasons. I'm going to barely touch on the ones that have already been addressed. But number 1, why it doesn't help kids? Because, as Tate said before, no K-3 student in the state of Wyoming is currently receiving instruction on sexuality. That doesn't come until 8th grade. And I'm a junior high teacher, and it's really it's mostly just based on personal responsibility. It has nothing to do with the topics that seem to be implied by this bill. Why doesn't this bill help kids? Number 2, because there's LGBT kids in our schools. They see it and they feel it when their legislators enact policies that they see as discriminatory. And these are kids that already face really high levels of bullying, mental health issues, and suicide. So when adults like us who are supposed to be making sure that they're okay and making sure that they feel safe in schools and they're ready to learn the things that they need to learn, when we're instead targeting their community with the full force of the state government, things can feel helpless for these kids. And that's a really dangerous place for kids to be in. So why is this bill not helpful for kids? 3, because policies like this scare off educators. Gay educators, educators with a trans kid, educators with a lesbian sister, anybody with a deep connection to the LGBT community or just a member of their family who's LGBT is going to be less likely to continue or start their teaching career in a state where this law is in the books. And keep in mind that we have a crippling teacher shortage right now. I checked today, we still have 16 teaching positions open in my district, which is very sad and very scary because those are kids who are going to have a long-term sub and maybe they're good, but for sure they're not trained the way that we are. We need to be attracting teachers, not scaring off a giant chunk of them. Why is this bill not good for kids? Number 4, and this goes to what Grady was saying, because this bill encourages an already sue-happy culture that is harming our schools currently, targeting our teachers, and eventually this negativity is trickling down to our students. In addition to the obvious financial costs that lawsuits incur on districts, even if they're justified or even if they're frivolous, this bill goes beyond that by introducing doubt. Okay, so I want everybody in here to imagine that they're a second grade teacher. Okay, so much like the situations presented earlier, student A calls student B gay or a fairy or something much worse. Okay, now best practices for a teacher in that situation is you address it immediately. Okay, that's what you do to support student B. But instead you're thinking about a law that Wyoming just passed. And if you're breaking the law by addressing it because we are talking about sexual orientation, or if you're going to be held liable because student A doesn't like the way that you handled the situation and is now accusing you of indoctrinating their kid. So you're thinking about all of these things when really the only thing you should be thinking about is supporting student B. Okay, and it's that wall of doubt that this bill creates, the wall of doubt that where basically the Wyoming state government is standing between the teacher and the kid and those little situations that are so crucially important that really does the most damage. And 5, why does this not help Wyoming kids? Because this is a Florida law for Florida issues and Florida politics. It's not Wyoming. Our mantra has always been, do what you want, just do it on your side of the fence. And if we're gonna disregard that just to become a little footnote in national politics, then I really feel like we're doing our kids a disservice. So again, those are just 5 simple reasons why I think this bill doesn't pass the basic test of does this help our kids. Please vote it down now before it can do any more harm. So thank you for listening, and if you have any questions, I'm here.
Thank you, Mr. Chairman. Thanks for being here. Appreciate you. Professionally, I'm a student that comes up to you. I trying to figure out my life. I'm scared. I'm being bullied. I think maybe it's time for me just to be someone who transitions. And I don't want you to go to anybody. But professionally, how would you handle me? I'm bawling. I'm upset. I'm scared. How would you go about professionally and maybe the requirements of your district to help me through maybe what I'm seeing on social media? Maybe just transitions the answer. Maybe just being gay is the answer. What would you do with that student?
And that's an excellent, sorry, Mr. Chair.
Thanks, Mr. Chairman.
That's an excellent question, one that's really difficult to answer because obviously I'm not going to get into the specifics of should they transition or should they not, but the number one most important thing is that that kid knows that they're supported. And that's something that I feel like this bill might get in the way of, because if I just like, whoa, like run to the counselor's office, they're gonna be even more traumatized. So basically just making them feel supported, making them feel heard.
Follow up, go ahead.
In your professional opinion, when I come up to you, do you think it's time probably to go to the parents as a teacher? Do you think, and you're a teacher of the student, professionally, do you think it's appropriate to go to that child's parents?
Go ahead, Mr.
Sorry. Really bad at this.
Very good.
So again, that's just going to be a professional judgment. Usually, if it seems like they're going to come out or something like that and they're in a vulnerable state, I usually tell them to pump the brakes and then just kind of avoid that situation, because it really, right now, the environment is, you feel pretty liable for a lot of things, even things that aren't your fault. So yeah, it's just going to depend on the situation.
One more follow-up question.
One more, go ahead.
Is there a line that professionally we can overstep and say that we're breaking the law in those situations?
Mr. McKenzie.
As educators?
Go ahead.
I don't.
Tough question.
I don't know. It is a hard one. Sorry. I don't know how to answer.
Sorry, Mr. Chairman, but that's okay. Just be honest.
Yeah, just I try to be as professional as humanly possible in those situations. And yeah, I think just making sure that they're safe first and foremost. That is my duty as a teacher. Like if they're saying they have suicidal ideation, I am for sure going to bring that to parents, to everybody that needs to be involved with that.
Thank you, Mr. Ford. Oh, go ahead. Representative Brown, please.
Thank you, Mr. Chairman. What was your last name? I'm sorry.
Ford.
Ford.
Thank
Like
you.
the truck.
Mr. Ford, I'm curious if you can give me, I'm struggling with the misconceptions that I believe that this bill does versus what it really does. I think there's probably two bills here, right? The first one is saying we're not going to teach gender identity or sexual orientation in a manner that is not age appropriate or developmentally appropriate for students in accordance with standards established by the State Board of Education or for students in grades kindergarten through 3. That's one bill in my opinion, right? And we're not going to go down whether or not that's in this bill. Then the next one is the discussion about if we have something going on with a student, as outlined what we have here, it says you guys now have protocols on how to handle what happens, right? The parents now have access to their children's information, all those types of things. So I guess I'm trying to find out, I always talk about black helicopters, right? And I feel like the black helicopters are slightly circling around on this bill because I'm not understanding where from your point of view, and if you can help me, I'm being sincerely honest here, where from your point of view, what it is that we're restricting that you actually want back in your classroom and in your control. What is it that we are saying with this bill is out of line and out of, I just completely out of line to the point that you took off work to come down here and talk to us. If you can help me understand that, I would truly, truly appreciate it. Thank you.
Go ahead, Mr. Ford.
Mr. Chairman, and I think it's a great question, and I'm not saying that anybody here is saying that you wouldn't want me to address that. What I'm saying is the vagueness of the bill creates that doubt that in those critical moments where you have to make a split-second decision and that decision could really impact the kid, I'm going to be doubting myself. And it's because of that vagueness of the first part. I think the first part is of this bill, the one that you were talking about.
Follow up, go ahead.
Thank you, Mr. Chairman. I guess the vagueness, I think, is stemming from what we've discussed earlier on the discussion here. Our enacting clause here and our long title of the bill says prohibiting classroom discussion. If we change that over to classroom instruction, and it becomes about instruction-based information, and that the title matches what is actually in statute. The title doesn't go into statute, right? So, but what would go into statute would say, Mr. Ford, you're not allowed to teach gender identity or sexual orientation in a manner that is not age appropriate in the grades or in grades kindergarten through 3rd grade. What's vague about that?
Go ahead, Mr. Ford.
Mr. Chairman, so I think it is the different interpretations of all of the words there. So a teacher is going to define teach in a very different way than maybe a legislator is going to define teach. And an angry parent is for sure going to define that in a very different way. And that's where that doubt comes. That's where the liability, I think, comes from.
Anybody else? More questions? Thank you, Mr. Ford.
Thank you.
Please go ahead.
Hello, thank you, Mr. Chairman and committee. My name is Abby Kircher. I am a teacher. I've been a teacher in Wyoming for 20 years now. I'm a parent of 2, a very amazing non-binary child, and another one. But I'm not here as a representative of my district, but I do represent teachers because I work with teachers, and teachers are scared. Teachers are afraid to talk. They're afraid of this bill, so I'm here. I love what I do. I just completed my master's. I'm a very qualified teacher. We all support all of our students. We want to support them the best way they can. And for all of them, not just particular ones, every student in our class deserves that. We all want to engage our families and we want them to be part of their students' education. It's important for all of us. As a special education teacher, it's super important that my parents, my students' parents, are on the same page as me in what we're doing, because it works better for the children if everybody is working together. As a special education teacher, you're making my job impossible. Many children with cognitive disabilities are unable to decipher pronouns. So when they use she, her pronouns, when they identify as male, who's getting thrown under the bus? Me, my students, my paraprofessionals? Some of my students are not capable of understanding the difference, and this is just going to snowball. I have other students. I had a student whose family included 2 moms or LGBTQ teenage siblings? When we do family pictures, are they not allowed to participate? Because they're protected. They're protected under equal access. They can participate in instruction when we're talking about communities and families and what their parents do. My dads are firemen. We can't talk about your dads. That's instruction. We're talking to our children. On a side note, I've had discussions with parents who don't want their children to be exposed to LGBTQ ideologies. I've had discussions with parents. We've talked respectfully. We found ways to work through. We found ways to work through it where everybody was okay, because it is just a fact that this child's parents were both men. It's a fact. It wasn't teaching LGBTQ values. It's a fact. And to say that we can't talk about it in instruction, it's going to come up, because in those ages, we are talking about community members. We are talking about family members. And instruction versus discussion, kids learn when we're discussing. When we're just instructing, they're just listening. When we're discussing the topic is when they're learning. Lastly, we're struggling with teacher retention. I know teachers are applying for other jobs because of this bill. I've applied for other jobs because I'm trying to get ahead of the rush of teachers that this bill is going to send running. I ask you to please vote no. Do not support this bill. Thank you, and I'm here for questions.
Thank you. Anybody like a question? Go ahead, Senator Office.
Thank you. Do these bills signal meaningfully to our students? I mean, again, whether we're interpreting it one way or another in the A paragraph, which is open to discussion, what is classroom instruction? One of our interim topics is mental health, and it's mental health both for students and for our instructors, our teachers. What is the implication of this type of legislation when we're contemplating mental health for both our students and our teachers?
Go ahead, Ms. Archer.
Sorry, yes,
Very
thank you,
good.
Mr. Chair. Thank you, Senator Ruffus. It's horrific. I have a paraprofessional in my classroom who has an LGBTQ student who's in junior high or high school now, who the last legislation session sent them into a hospital. Teachers are scared. Teachers are scared that they're going to say the wrong thing by supporting our students, by supporting our families. Like, families want to be part of their children's education. Talk to your teachers. We want you to be part of your kids' education. And parents are afraid too, because if anybody in their family is LGBTQ and their student goes, we can't talk about it, it's detrimental to everybody, to teachers, to students, to families, to community, to everything as a whole. Mental health, everything. Yes.
Further questions for Ms. Archer? One more. Go ahead, Representative Brown.
Thank you, Mr. Chairman. So, Ms. Steves, I appreciate you again taking time out of your day. I appreciate what you do, because after sitting on this committee for 8 years, I have the utmost respect for teachers. I tell everybody and anybody else who's a teacher out here, I couldn't do it, right? Just like you guys probably couldn't sit up on this side of the dais and deal with the crap that we put up with, right? So I get it. My question is, if we looked directly at the discussion of defining classroom instruction, what I hear multiple times out of this discussion is we're afraid of what that ambiguity means. And if I have a discussion with the student, is that considered classroom instruction?
Mm-hmm.
If we defined that and took that down to a more narrowly scoped definition of what that means, would that be more palatable than just saying classroom instruction? Because I think, as I'm sitting here looking at this, I think that's what I'm hearing from you guys, but I don't know. Maybe I'm misinterpreting what you guys are saying, but what I'm hearing is we're afraid to say something in the classroom because everything we do inside the classroom is considered instruction. And so I guess maybe I'm trying to find out if there's a better way for us to make this more palatable, right? So I'm in the mode of compromise. Everybody should walk away from the table pissed off a little bit. So
go ahead, Ms. Archer.
Thank you, Chairman and Representative Brown. I think instruction is, sorry, it just gets me all riled up because it's very important. When you guys were talking beforehand about taking out discussion and just putting in instruction, like in order to say what's instruction, right? So when I'm in my classroom and we're talking about family units, it's part of the instruction to talk about family units in the community. So it is the discussion. So I don't know how you separate those two. What exactly is instruction? As far as I'm concerned, when I'm teaching in a classroom, it is all instruction, whether we're having discussions or whether I'm teaching from a curriculum, because I'm always teaching them. Whether it's facts, whether it's science, whether it's math, whether it's how to be nice to your neighbor and not steal their pencils because they're their pencils. It's always instruction. I don't know when I'm not being a teacher when I'm in the classroom.
Okay, appreciate it. Thank you.
Further questions? Go ahead, Representative Berger.
Thank you, Mr. Chairman. Thanks for being here. In your professional opinion, and when you set your lesson plan and you go by your instruction, is there anything such as a perfect day or a perfect lesson and a perfect direction? Even with state statute or change in these laws, will we be able to have control the perfect day every day as teachers?
Ms. Hercher, how's your
Thank you.
perfect day looking?
Oh, you done? Thank you, Mr. Chair. Representative Berger, 1,000% no. Maybe a snow day.
Mr. Chairman, follow up, and why not?
Mr.
Go
Chairman.
ahead, Ed.
Mr. Chairman, because we're working with children. We're working with students. Well, we're working with humans because honestly, even as adults, we don't have perfect days. It's just, we're humans. We do the best we can. We do the best we can for our students. The students do the best they can. Everybody's doing the best they can.
Very good. Very good. Further questions? Anybody? Thank you.
Thank you.
Go ahead, please.
This is-
Green.
Thank you.
Green is good.
Okay. Good afternoon, Chairman and committee. I'm Susie Savage. I am an 8th grade English teacher in Laramie County School District 1. And just give you a little insight into how a teacher brain works. I grab the document and everything I teach my students about close reading and text evidence and trying to break it up and understand it. So no school district shall permit classroom instruction, which we said is teaching. So we think of a lesson by teachers or any other person on sexual orientation and gender identity. So yes, we are humans in a classroom. I'm not a robot. The students aren't robots. I don't teach my lesson like this and they just listen. It's all interwoven, the humanness, a community of learners, and we're all different. That's why, for one reason, this bill is not necessary, because there is no standards by our state agency on sexual orientation and gender identity, but the vagueness and the humanity of a classroom does create fear for teachers. Because if we cross this line, oh, that student brought this up. Oh, no, they're talking about this. Oh, what do I say? Oh, can I have a character in my book that is LGBTQ? Can I have any characters in the books in my classroom that are LGBTQ? Oh, no. I'm also a grandmother. My granddaughters this past year were 3rd grade and kindergarten here at Laramie County School District 1. They have an Uncle Sam who's gay. So if a teacher did a read aloud and we're looking for connections or background knowledge or drawing pictures or again talking, can they talk about Uncle Sam? Can they talk about Uncle Sam and his boyfriend? Like, why the stigma? We can talk about everything else. We can talk about other kinds of differences, differences in religion, differences, your parent is a Democrat, your parent is a Republican. But this one difference right here, that one, we have to somehow leave that out. Uncle Sam is part of their life. Uncle Sam is a good, kind person. Uncle Sam has a master's degree and is a successful accountant. But it's like, because his sexual orientation doesn't fit what? Like, who's to say this we can accept and this we won't? So as a teacher, I'm scared. I'm waiting. My husband's like, oh my gosh, you're going to get fired. It's going to happen. I just know it's going to happen. And for my own granddaughters, like, why is Uncle Sam taboo? So that is all that I have. Oh, I do have one more thing. Also, as a teacher, I'm afraid of this. Notify a student's parent or guardian immediately if there's a change in the student's services or monitoring. Like, I'm monitoring what? Related to the student's mental, emotional, or physical health or well-being. If a student tells me, or they write in their journal in a quick write, and I can infer you're gay because you're a girl and you're writing about your girlfriend, I don't think there's anything mentally wrong with that kid, emotionally wrong with that kid, or physically wrong with that kid. So what does this even mean? Like, I don't know. I don't think there's something wrong with a kid if they're LGBTQ. That's all. Thank you.
Anybody from the committee have questions? Okay. We're going to take a 10-minute break because some bladders cannot extend this very much more longer. And that makes it 4:16 when we come back. Some bladders, including mine, are getting full. I saw you sneak out.
Yeah, I said I was gonna. Came right here. How am I supposed to talk about my reading? This is my job. I reached my hands. Yes, sir. It was like, there's no way that start coming.
Quorum. Okay, we're back. It's Verizon Times 417. Keep going on this. We're taking public comment on, I forgot the number of the bill. 24 LSO 0076, and this is the group that is for the bill. Please, somebody take off.
I'll go ahead. Thank you, Chairman. My name is Jennifer Hopkins. I'm a wife. I'm a mother of 6 children, and a couple of those children are parents themselves. I've also recently been elected to a board of trustees in my town. And but I'm speaking on behalf of myself. I believe that parents are the first educators of their children. I believe that should always be respected throughout their life. You supply a service for us, the public schools. If we choose to participate in that, we can go ahead and do that. You know, I'm listening to everything today. I have 2 solutions, just really quick. What might cure these extra discussions with children and their teachers is possibly maybe we should concentrate more on curriculum and not the time of day and time of idleness or such conversations. Just a quick note. So as a primary educator of my husband and I, that we are with our children, I feel really uncomfortable of teachers having any discussions of any type of sexual orientation with kids. I just don't. I have a quick example. I wasn't going to go through the examples, but I think it'll be better to help you understand where I'm coming from. So my son was born. My youngest son was born after 4 girls, and they were all dancing, and they had the costumes and everything. So of course my youngest son would, you know, he wants to be like his sisters. So he would wear the costumes, he would wear nail polish. And what did I do? Did I have a discussion with him? No. I just told him, maybe costumes are not the best thing to wear in every situation. You know, if we're going to school, if we're going to a church or something like that. I would say that to any of my children. Does he still wear dresses today? No. Does he have an issue with anything going on? No, because as we know with younger children, if I were to go into a really long discussion about his sexual orientation because he was wearing a pink tutu with colorful stripes, he would have just looked at me and the next thing been out the door and on playing on a toy outside. So we had appropriateness of their development appropriateness. So I would never discuss anything like that with my own children. And as an educator of my own children, I have homeschooled. I have private schooled them, and I've also participated in public schooling for some of them. Another thing I thought about while I was sitting here too is that how do teachers react when they're in an uncomfortable situation with their students? Well, I'll tell you a personal story. Back in Phoenix, I was shoplifting with some friends, and the buzzer went off. My friends took off, and I was standing there left alone. And guess who I ran into? Well, you wouldn't know, but I ran into a teacher, and I told him my story. What was the first thing he did? He encouraged me to go back in and tell my parents. So as a parent, I would want to know what was going on with my children. I participate in those services that are provided because I choose so, and it may help me with a certain child. So I do support this bill. I do not want teachers engaging in such conversations with my children without my knowledge or my permission. And that's what I have. Thank you, Chairman.
Does anybody have a question for Ms. Hopkins? Thank you very much.
Thank you.
Next.
Good afternoon, Mr. Chairman and Mr. Co-Chair, members of the committee. My name is Mark Moody. I am a regular citizen in Laramie County, residing in Senate District 31 and House District 43. We have heard in the past, we don't need this bill. None of the problems occurring in other states is happening here in Wyoming. However, it is happening here. In the news, we saw what happened in Rock Springs. We saw what happened here in Cheyenne from earlier testimony. That's why this bill is needed. Now we keep hearing, we are not Florida or Arizona. Very true. We don't have palm trees like Florida, Arizona, nor do we have warm winters like Florida, Arizona. It would be nice. However, Wyoming politically is Florida times 5 and Arizona times 10 to 20. That is why they already have this in law. We should be having it in law. We should be leading the way with Florida and Arizona. And I'll say this is why supermajority of Wyoming citizens across the state are asking this to go through this committee today, or again, November, when you have the time to do the amendments, be introduced during the budget session, sign the law. Let's follow the lead of Governor DeSantis and what they've done in Florida and other states too, and other governors, including presidential candidates, and let's lead the way on parental rights here in Wyoming like they have in other states. I'll stand for questions.
Questions for Mark? Go ahead, Representative Brown.
Thank you, Mr. Chairman. Thank you, Mr. Rudy, for being here. Question for you, and I'm trying to maybe take the flip side of the questions that I was asking the teachers here. So put yourself in a teacher's shoes. And one of the things that I'm starting to get a little bit better picture of is in second grade, is first and second grade, we start talking about mommies and daddies, all right, in that family unit. If we pass this bill, how do you envision having that discussion as a teacher without having any level of gender identity or sexual orientation?
Go ahead, sir.
Okay, Mr. Chairman, thank you for the question, Representative Brown. Again, if there's a mass situation, go back to the parents, go back to the parents.
Mr. Chairman?
Go ahead, restate that.
Yeah, if you can maybe elaborate on that, I don't understand. So you're saying just utilize the term parents and that's it?
Go ahead, sir.
That is correct.
Okay.
Okay, further questions? Thank you.
Thank you.
Who's next?
Thank you for having us here today, Mr. Chairman. My name is Marie M.H. Due to my job, I would prefer not to have my last name on record. For the last 22 years, I've been covering education at legislative committees just like this, but I'm not here on behalf of my professional career today. I'm here on behalf as a mother of 3 children, all 3 autistic, all 3 on the spectrum. I take that job very seriously, above and beyond any other job I've ever had, and my children have always come first. I have taken 2 districts in this state to WDEIDEA court. If you don't know what that is, that's special education court. I've won a total of 37 cases against 2 districts here concerning education. So I'm pretty well versed when it comes to education law. I have one child that is severely autistic, and this last school year encountered a situation in which he didn't know how to gender the teacher. And it was quite an ordeal. The school wanted to suspend him. We went through the whole process. I went through the school board. I went through the entire process. It was a muddy, muddy mess. When you have a child that's on the spectrum as severe as my child is, they don't understand this linear path that we're talking about. They don't understand that you might have 2 daddies, or you might have 2 mommies, or you might have a mom and a dad. They don't understand this. And then they start questioning things. Well, I'm here to tell you that I am their mother, not you, not Mr. Northorpe, not the school district, not the teacher. I am their mother. Therefore, I have the last say of what my child is presented with. I have the last say in what they're taught, educated, instructed with, whatever term you want to use. I will also add that I am very hypervigilant on going over the standards every year, because they change every year, from year to year, they change. The school district that my kids go to will tell you, I ask in May for the finalized draft of what's going to be taught in the next school year. And I go through it with a fine-tooth comb for all 3 kids, and I opt out. I very rigorously use the opt-out. And that's not fair for someone like me to have to go through and fine tooth and go, nope, they can't do this. Let's find an alternative. They can't do this. Let's find an alternative. when we should have opt-in for certain things. I think if you want to talk about gender or if you want to talk about sexual orientation, that's great, but let's make it appropriate. Let's make it an opt-in. I don't feel like parents are getting the fullness because oftentimes I have to go looking for the information and the school websites are not very clear. You really have to dig down into the school websites to find the information that you're looking for. And I've had the unfortunate experience, let's say, of going to both the school and the district my kids attend to get that information and being treated like a hostile, threatening parent. You see me here today, I speak very softly. I don't think I'm intimidating or threatening in any way. I just want to know what you're teaching my children. And I have that right to know what you're teaching my children. And I have that right to opt them out. What I'm asking you to do is this law, as one of your reps today, or senators, I'm sorry, rep, I'm sorry, keeps pointing out, is there some ambiguity to it? Is it a little bit vague? Absolutely. And as a words person myself, I would ask you to define that down a little bit more, because I would be very appreciative of that. But at the end of the day, I'm still mom, and I still have the last say, period. Thank you for your time.
Go ahead, Representative Provenza.
Thank you, Mr. Chairman. Thank you for being here. If we drafted the bill in a way that basically tried to take gender out of it, so we're only referring to teacher, instructor, not Mr. or Mrs., everybody uses the they, them pronouns so that ultimately parents get to choose how they want to interpret gender at home. I'd love to hear your thoughts on that. Thank you.
Go ahead, Marie.
Thank you. I don't play the pronoun game. If you tell me you're a woman, you're a woman. If you tell me you're a man, you're a man. And that's how I raise my kids. That's how we should be doing it in our schools. If a teacher says I'm a woman, she's a woman. If she says I'm a man, he's a man. And what we don't need though is discussion behind that. Oh, this is why I'm a man. Or maybe I was a woman, then became a man. That's what I have the issue with.
Go ahead, Senator Rothfuss.
Thank you, Mr. Chairman, and thank you for your testimony. What you note and emphasize is the fact that you should have the final say, and I think we generally all agree that you're the mom and you have the final say. The concern that I have certainly is that the legislation is drafted as an express forbiddance of teaching in this space. And if you as the mom want to be raising your kids in a certain way, and I as a father and my wife, we want to raise our kids in a certain way, the challenge is when these ways conflict and when we have different views. So for me, for example, I want an open, loving, accepting school environment for my kids, regardless of sexual orientation, gender identity, for all students. I want that to be fully normal in the classroom discussion. How do we get to a point where we both get our way? And obviously this legislation isn't it, but how do we get there?
Go ahead, Marie.
Thank you, Mr. Chairman. Actually, I disagree with that. I feel like we all live here for a reason. Wyoming's one of the greatest states. It just is. This is where my family has come for over 100 years. And I will tell you, this is the greatest state in the union. We have a way of living here, the Wyoming way. As someone else said earlier, you play on your side of the fence and I'll play on my side of the fence, and somewhere we'll meet in the middle. And that's perfectly fine. We're not asking you to remove this or do this or change you or anything like that. What we're saying is, these are my kids. There's a boundary. You can't cross that boundary. I get to decide what my kids learn and what they're presented with. You get to decide what your kids learn and what they're presented with. And at the end of the day, why are we teaching anything outside of academics? Reading, writing, arithmetic, math, or science, history. There's no need to have this discussion about, well, you're a man, but you decided to become a woman, or you're a woman who likes women, or you're a man who, there's no need for that, because kids will eventually learn that down the road, that later on when they start figuring out their own gender and their own sexuality. That's not something I believe teachers should have the key to. That's your job as a parent. And maybe we should emphasize that parents should be taking more responsibility and a role in raising their children instead of allowing the teachers in the school districts to do so.
Mr. Chairman, quick follow-up.
Okay, follow-up.
Thank you. But what you're emphasizing is that theoretically we'd both and everybody would be able to have their own teaching environment and have their students educated in what we choose to have them educated in. And then you stated how you thought education should go. And again, certainly something that you're entitled to believe, but therein lies the challenge is that I don't necessarily agree with all of those provisions that you laid out. And I want a different classroom environment. And so when there is contrast, getting back to the leave well enough alone, the state of just kind of living in and letting live. With this circumstance, we're passing legislation that explicitly chooses sides and prevents topics of conversation from occurring in a classroom. So we're restricting what is and is not allowed to be talked about. I don't understand how that's consistent with your view of letting everyone live and let live.
Go ahead, Marie.
Thank you, Mr. Chairman. So to give you an example, today I went down to my child's junior high school to take care of a little last minute things before he starts school tomorrow. One of those things was opting him out. Again, as I said earlier, I have the right to opt him out. I also believe parents should have the right to opt in. We should have the set of topics that maybe are controversial or political or whatever label you want to put on it. Maybe those topics should be both an opt-in or an opt-out kind of system, because it's quite undue and unfair to me as a parent to have to go through all this curriculum and go, oh, I'm opting out of this, I'm going to substitute this. And I work very hard with the school district. I work hand in hand with them, we make it happen, and my kids do not miss out. But what I'm saying is, to make that happy medium you're discussing, we probably need to find, and this is probably more of a district thing rather than a legislative thing, an opt-in, opt-out system, which balances each other. Because the same way I have to opt out, you should have to opt in.
Representative Clauston had a question.
Thank you, Mr. Chairman. Marie, thanks for being here and being so vigilant. I mean, being here today and for your kids. I think really what I'm hearing, the point of this legislation is, besides we all want what's best for our kids, right? And I'm also a local control people, but what I'm really hearing from you and from everyone else, no matter what side you're on, is we don't want our kids receiving instruction that's religious or personal or socially based, right? We have our standards that we want taught, and these other agendas need to be left out of our classroom. Is that what you're telling me?
Go ahead, Marie.
Mr. Chairman, that's correct. Just may I add to that?
Sure.
So we're Jewish, and in the same way I would not share my Jewish faith with you or the school or anyone else. My kids don't, because one, separation and all that stuff. I believe that this topic that we're discussing today is along the same lines.
Representative Brown, you had a question?
Thank you, Mr. Chairman. I'm just curious. I'm trying to formulate exactly how I should ask this, because as you're stating this opt-in, opt-out, right? I'm trying to think, again, I'm trying to take a bill that nobody in here agrees upon, and I'm trying to make it more palatable to where everybody can walk away and have a little bit of something they wanted, but a little bit of something they didn't want also made it its way in, right? My question to you is, you say that you shouldn't have to do this. Would you say that you're in the minority of the amount of parents in your district that are working with your district to opt out of your lesson plans that you opt out of?
Go ahead, Marie.
Mr. Chairman, I would say no. I'm actually in the majority. I've spoken with my local school district and the parents, and by far the numbers of using opt-out of certain things increases every year. I think when I talked to the district 2 weeks ago about this, it was at a 47% increase over last year, and they're expecting it to be closer to 60% this year.
Mr. Chairman, follow up?
Go ahead, follow up.
So I appreciate that, because what I'm thinking of at this point is this lends itself to be more of a school district discussion, right? This becomes more of a local discussion as opposed to a statewide discussion. Because I would venture to guess here in Laramie 1, you would be in the minority. When you've got 20,000 kids, roaming around in the schools of Laramie County 1, I can't imagine that we have a minority of students being excused from the classroom while we have a majority of students being excused from the classroom while we have a minority being taught about certain subjects. that would lend itself to me that we actually have a problem. And the school board, if you're from Laramie County 1, I saw you kind of shake your head. My concern would be then, why isn't the board taking a look at what curriculum is being taught if we're excusing 50% of the students or more? And if that's the case, it has nothing to do with this, it has nothing to do with gender identity and any of that kind of stuff. We're talking about math, science, and reading, right? So I guess my question is at what point do we say we are trusting our school board to make the decision? And if you're asking us for this, are you going to be coming back in a year saying, I also want you to dictate this from the state level, right? Because to me, it seems like the state coming down and forcing this down the throat of the local school districts takes away that local control and that ability of those local electeds. So maybe elaborate a little bit on that if you could.
Go ahead, Marie.
Mr. Chairman, with due respect, I would prefer not to say where my children attend just because of the nature of my job. But I do know that there is a lot of contention among our local school board at present for reasons. But what I'm asking is that, like another person had stated earlier, and forgive me, I forget who said it, but there is no support right now for school boards to put in an opt-in, opt-out. You know, most school boards across the state maybe have an opt-out system, most don't. But there's no provision, no backup, there's no support from the legislative side that says, hey, yeah, maybe you should look at an opt-in, opt-out system. Maybe you should, reevaluate that. Reevaluating our curriculum here, or not here, but in my children's school district is one thing that we're looking at and working toward as well. I'm sure most of the state is. And it's something that I keep a keen eye on, and I do keep in conversation with the director of curriculum for my kids' school district, because there's a lot I have issues with. Like, one, they don't talk about the Holocaust at all in the district. I'm a Holocaust survivor's granddaughter. We don't talk about anything related to how many 6 million Jews that perished. We don't talk about any of that. That's a tragedy. That's traversity, because much of our eastern side of our state was founded by Jewish people that came over, a long time ago with the pilgrims, but we are not pilgrims, I'm sorry, pioneers, but we don't talk about any of that. So I do have a lot of issues, and we are discussing it and we are moving forward, but as you guys know, it's slow moving.
Okay, any other questions? Thank you, Marie.
Thank you.
Please go ahead. Green's good.
Okay. Hello, Mr. Chairman, co-chair, and members of the committee. My name is Laura Tolliver Pearson. I'm a 6th-generation sheep rancher, school bus driver, wife, mother of 3, and grandmother in Southwest Wyoming. Parental rights in education, that is the discussion today. The U.S. House of Representatives passed H.R. 5 on March 24th, 2023, the Parents' Bill of Rights Act, which was founded on 5 pillars. Parents have the right to know what's being taught and all material. Parents have the right to be heard and not ostracized for it. Parents have the right to see school budgets and spending. Parents have the right to protect their child's privacy. And parents have the right to be updated on any violent activity in school. We must be proactive and not reactive. PG-13 rated movies are not meant for children under 13 without parental consent. Question: why does this bill mention K through 3? At a minimum, it should be K through 8. Sexual issues shouldn't be discussed before 13 in an educational setting, other than the basic boys have penises and girls have vaginas, and at some point both will go through a thing called puberty. Why are we wanting to expose children to these things before they are developmentally ready? Sexualizing our children is not okay. The First Amendment talks about abridging the freedom of speech. When you look up the meaning of abridge, it means to shorten by omission of words without sacrifice of sense, condense. To shorten in duration or extent. To reduce in scope, diminish, or deprive. By not passing a parental rights and education bill, parents' rights over their child's upbringing and education is being condensed, diminished, and deprived. Also, the First Amendment says, "The right of the people peaceably to assemble and to petition the government for a redress of grievances." We as parents are coming to you, our government. We have the right to petition our government for a redress of grievances. Our inalienable rights as parents are being infringed upon within the public education system. I'm not here today to expose the dirty laundry that is happening in our education system around the state. But to say it's not happening in our state would be considered an intentional omission on the part of our leaders. Protect our children's innocence. Let them be kids, and protect our families. I would like to close with a segment from George Washington's farewell address. And let us with caution indulge the supposition that morality can be maintained without religion, whatever may be conceded to the influence of refined education. Reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle. Thank you. Thank you.
Or anybody else that would like to testify for or against? 1, 2. Okay, so this is the ones that are against today, right now. So 4 against, and then 4 more for, and then we're gonna call it quits after that.
Mr. Chairman, you do still have people online who would
Oh,
like to
yes, we still have
testify.
people online, yes. So see, we're gonna be here till,
Carry too long. Carry the next subject over, but they ought to ask for any testimony that can't be here tomorrow.
okay, the next bill actually has, I'll talk to you later. Okay.
Morning, Mr. Chairman, and to the committee. Oh, I had to push the button. Good morning, Mr. Chairman, or both, and to the committee. My name is Amin Medina, and I'm standing in opposition of this bill. I'm the parent of 2 young children in Wyoming elementary schools. My oldest child, now 10, came to me in the summer between 1st and 2nd grade to tell me that they neither feel like a boy nor a girl, or sometimes like a girl and sometimes like a boy, but mostly neither. Their mother and I agreed that the best way to support our child was to let them be in charge of defining their own identity, and decided to support this decision. We talked with their teachers, and their teachers, supporting staff, and administration did their best to support my kid by using they, them pronouns, which is what we wanted as parents, as was our right. I asked my kid about what it meant to them that their teachers did this. They reported that it felt really good because it made them feel respected, that it made me feel respected for who I am. And it made me happy that they respected me as who I am. This context is important to understand my concerns as a parent regarding this bill, meant to protect my rights as a parent. First, my child has not necessarily decided what gender feels best, if any. I, as a father, and their mother, kind of heads of household, support their right to question and try on what identities feel right. I fear this bill would have forced my child into a decision to choose one way or another, as to curtail any conversation about gender in their classroom. Frankly, I don't think this is a decision up to the legislature, but rather my decision as a loving father. Second, the proposed bill would put my rights as a parent in conflict with the state's rights. If this bill goes through, my child's teachers would be mandated to reject my rights, which would have left my child feeling isolated and disrespected. These are the primary factors of suicidality. I'm much happier with the outcome that our current system produced. My child has been left feeling happy and respected. Finally, I don't fully understand this bill. Some parts go through K through 3rd, some parts seemingly affect my other student, and I have a degree in writing. I'm working on a second master's degree. I just don't get it, and I would hope that it could be more easily understood. Finally, I'm grateful for this education committee wanting to defend my rights as a parent. I'm grateful for the work that you put towards that aim, but this bill would place other parents' desires over my rights, which would be simply overreach. I would invite you to defend the respect and dignity my child was afforded in Wyoming schools by keeping this bill from our approaching budget session. Thanks, and I'll stand for questions.
Sorry, I didn't catch your name.
Ammon, like salmon. It's hard to pronounce. It's okay if you don't get it right.
Any questions for Hammond? Thank you, sir. Next.
Hi there. That little closer. I'm Kristen Aaron Balderas. I am a citizen here in Wyoming. I am leader of a nonprofit organization. I am a Indigenous woman here in Wyoming, and I am also the proud mother of wonderful children. I happen to hit the lottery when it comes to LGBTQ kids. In that I happen to, out of 5 children, have one child who identifies with the gender they were born with and happens to like the opposite sex in terms of attraction, romantic attraction. So that means I have 4 queer children. I grew up in this, in Wyoming mostly. I came from an Air Force family, and I came from a very conservative home and a very loving home. So a lot of the nuances that come with gender and sexual orientation, I wasn't raised, with these ideas being common in my household. I've been a mother for 18 years, and that is now, I've been a mother longer than I've been myself. And if there's one thing that I can tell you, I love my children fiercely, and I would do anything to protect them. At this point, I'm sure you all have noticed behind me, I have this beautiful little human, Soren. I've asked permission if I could talk about them for a moment. They are 10 years old, and they are absolutely hilarious. They are going into 5th grade, and they told me when they were in 1st grade, as we were getting ready for school one morning, that much like my friend Ammon here, similar story, I don't really feel like a boy all the time, and I don't really feel like I'm a girl though. And I'm like, you know what? That's okay. I don't really think that that's something that we have to worry about right now. How about we just worry about being a good human? And that's kind of the philosophy in our house. Just be a good human. And the more that, my child felt comfortable being who they are, the more they felt comfortable being who they were outside of the house, going to school, and solidifying that identity as, you know what, I'm right there, and I don't feel like a male or female. I just want to be a person, and I don't want people to associate me, with the boys and make me go and play football. I don't want people to make me, do dance or, what other girl things that they do. Soren just wants to be Soren. And when Soren's at school, some kids come to school and don't really, because they haven't been educated or exposed or don't understand really that I've encouraged my child to be who they are and be loving and just be a kind human. A lot of kids don't have that same experience. They don't have that as their norm. And so for me, this type of legislation, it makes me worried as a parent that when I send my child to school, that my kid is not going to feel fully protected or be as protected as I need them to be. Like it or not, kids can be buttheads. Kids can be rude. Kids can be hurtful. And, I thought it was I chuckled a little bit when I heard, can we just tell them, we don't behave this way and we don't bully each other and be done with it. I'm a mom of bullied kids, guys. I can tell you that absolutely is not a thing and does not work. Every day is a battle. It is a struggle. And all I want is for, this to not be more of an issue for my child to deal with every day. When they go to school, they just want to learn. They just want to do their thing. They just want to be themselves and accepted without there being whispers of, oh my gosh, they're gay, they're non-binary, they're this, and teachers silencing, nope, that's not appropriate. Actually, my child has been teased about girlfriends since they were a toddler. All of my children have. We're talking about, it's inappropriate, but developmentally appropriate material, I decide my child is on, it's a product of myself. It is my responsibility as a parent when they come home from school to debrief and to give them that education and to help them to build that wall, that thicker skin of, I'm so sorry, people are so mean to you. I wish that at school there was more support for my child in the form of, their teacher acknowledging their pronouns instead of calling them him again, and Soren quietly cringing and now being a little thrown off, and when they're next for their book report assignment. Little things like that really do impact a child throughout the day. I think about the little things that might unnerve me because of my past experiences in my life. They might not be anything, but if somebody says some word, I might get triggered and I might be like, wow, I have some work to do there. But as a child, it's just not the same. They're developing those skills. And I think that in order to create an environment where my kids and other kids feel safe every single day, destigmatize what this is all about. It's not about, protecting children. You're certainly not protecting my child with this 100%. If anything, you are this would potentially encourage more bullying, more cleanup for me, more, increasing counseling sessions through the week. As a parent, I'm a single mom. It takes a village to raise a child, and I need to be able to rely on my teachers at school, the counselors at school, my child, to be able to build those strong relationships with them and to feel safe enough to be able to be valued and to be themselves when they're there. And with that, I yield.
Green's good. There we go. Ms. Valdez, is anybody getting questions for her? Thank you very much for your testimony. Appreciate it. All right, flip a coin. Who goes next?
Mr. Chairman, members of the committee, I'm Marcy Kindred. I'm a local realtor. I'm a mom of 4 in Wyoming public education system and a founding member of the nonprofit Wyoming Family Alliance for Freedom, or as we like to call it, YFAF. I will gladly point out that we have no association with Mr. Winter's organization. We just happen to have a mutual interest of Wyoming families, and we just have a focus on freedom. I'm not here speaking for YFAF. I'm here as my whole self, as a mother, a business owner, a citizen of this great state. But I do want to lift up the experience of the formation of our nonprofit. A little bit of a backstory. We started just as a group of moms concerned about the influence out-of-state groups were having in attempts at policy changes at our local school district, mostly regarding book banning. I'm sure you've heard a lot about it. But very quickly, this nonprofit has exploded to every corner of our state. We have folks reaching out daily from all political sides of the spectrum, wanting to form chapters in their counties, seeking resources and support. It's been an incredible and very hopeful thing to be a part of. I bring this up because the influence of out-of-state actors in this bill is blatant. It's a carbon copy of Florida's infamous Don't Say Gay bill. We can look to Florida as a cautionary tale. We've seen it used in Florida to purge books from shelves, cut curriculum, and attack educators. And I'm sure not all supporters of this bill support it because they want those things. But that is what is happening in Florida. The growing popularity of our Wyoming nonprofit supports my theory that this type of legislation and policy is not actually reflective of the will of the majority of Wyomingites. Government overreach has never been and will never be a Wyoming value. A small but very loud group seems to be advocating for these ideologically fueled policies while claiming to speak for our whole state. And while Wyoming was kind of caught flat-footed with no defense against the push for them, that's just because most of us never dreamed it would happen here. This isn't Wyoming. We were caught sleeping at the wheel a little bit. But if my recent experience with YFAF is any indication, Wyoming is not asleep anymore. This is not the direction that the majority of our state wishes to go. Our teachers in Wyoming are not strangers dropped out of the sky with some agenda. Our teachers are Wyomingites. They go to our churches. They care about our community. We know them. Many of them grew up here. They just want to teach our kids. And we just heard from a bunch of them saying how this will interfere with their ability to do their jobs and how we're not hearing from a lot of educators because they are scared. So the title of this bill, Parental Rights, which I am absolutely for as a parent, this bill, while touting parental rights, gives more rights to certain parents and strips individual rights from others completely, which is so incredibly anti-Wyoming, it makes my head spin. I urge this committee to consider the long-term implications of any decisions made regarding this resurrected and copied Don't Say Gay bill. Let's learn from past mistakes of other states and improve our educational system by working on actual issues. The mental health crisis has already been brought up. We need to be working together to equip our children with the tools they need to succeed in our interconnected world. We as a state have always strived to embody our Wyoming values and stand as an example of strength and freedom. The Wyoming I know doesn't need to be influenced by out-of-state groups that don't understand us. We've got enough moral fortitude and strength on our own. Please do not let national agendas weaken our resolve. Thank you for your time and consideration. I will stand for any questions.
Thanks, Mr. Chairman. Thank you for being here today. Is there only one way to teach or even parent a child?
Thank you, Representative Berger.
Go ahead.
I will tell you, Chair, even from the moms within our group, moms and other parents in Wyoming Family Alliance for Freedom, we all have very different ways of parenting our children, and yet we all agree that this is not the way. This bill will not help or assist in parenting or teaching our children. Did that answer your question, Representative Berger?
Further questions? All right, thank you, Ms. Kindred.
Thank you so much.
Mr. Chair.
Last one. Go ahead.
We good?
Oh, you're good. Go ahead.
Wonderful. Mr. Chairman, members of the committee, my name is Lindsay Simoneau, and I represent the Wyoming Counseling Association. We are here to state that we are against this bill. What we have seen within the data and according to the Human Rights Campaign is that bills that address sexual orientation and gender identity, it's been a long day, I'm sure, for everyone involved, negatively impact the mental health of LGBTQ youth within the state. And so because of that, we do not support this bill at this time. Some highlights that have already been mentioned today that I do want to highlight towards the end of the day, that this bill will cost the state funds, whether those funds are in litigation, businesses avoiding Wyoming, military personnel who are anxious about bills such as this and how they will impact their children not wanting to be located within the state, but mostly our students. Wyoming students, Wyoming youth are paying attention to the legislature in a way they have not ever been able to before because of technology, but also because it is directly impacting them. What we are seeing is that as much as we as the legislature talk about growing our own, if they are not interested in staying here post-grad, that will become more difficult, and that over time will impact the economy. The Wyoming Counseling Association believes passionately about the mental health of not just the Wyoming residents, but its youth, because we recognize that it is Wyoming's future. With that being said, if we are doing things that we know are counteracting that, whether it is bringing forth this bill, whether it is bills that such as this increase levels of bullying within schools, which has also been talked about today. The question is, are we doing the job for Wyoming residents if we're not sure this will help Wyoming residents? You guys have had so many speakers today. And so for that, I will wrap up and stand for question.
Thank you, Mr. Chairman. We talked about mental health and bullying and suicidality in the last meeting. And unfortunately, it's not on our agenda today, but I'm wondering if you have any background on if we're shutting kids down in terms of talking about identity. They want to talk about it because it's not just that the teacher has to bring it up. Anyone can bring it up. And if this is a conversation that's shut down. We can't talk about it. One of the examples that we were given. What is the impact on our students knowing that the suicidality of this particular group of students is extremely high? I know that recently we had a 5th grader who died by suicide in this state. So I want to know what's the impact of this bill and the ambiguity of teachers and how they deal with children, and what is the impact on their mental health?
Please go ahead. And I didn't catch your last name. Is it Semino?
Semino, like the state park, but not.
Okay.
Mr. Chairman, Representative Provenza, I'll do my best to answer. There was a lot in there. Wyoming is still ranked number 1 in suicidality across the state. That is something that you guys get to talk to me about ad nauseum during the legislature. So I know that you guys are aware of that. It does increase for kiddos who are LGBTQ or identify as on the gender spectrum. That is something that we have seen data for from multiple national organizations, and it's also true for the state of Wyoming. The data that we find the most interesting is how bills such as this, which is to protect kids, that we have also seen data from the national, I'm going to need to get this organization wrong, the National Education Survey. I'm looking at Sarah, if you know what I'm talking about. Yeah. That bills such as this does increase those LGBTQ kids getting targeted. I understand that this bill is written for those who are K through 3, something that I have seen as a private provider, as well as having 2 boys in the Laramie County School District. Both boys have had kids with same-sex parents in their classrooms, starting from kindergarten. Both kids have also seen those kids be targeted, and that targeting has increased as this theme has been has increased throughout, not just on a Wyoming scale, but on a national scale. And so I do think that there will be a negative impact seeing this move forward within Wyoming school districts.
Slightly different question, but similar. Thank you, Mr. Chairman. Some of the bill we talked about opt-in, opt-out on some of these mental health measures. And I'd like to know kind of if you have any understanding of the impact of what that could have in terms of mental health screening, if parents have to opt in and don't necessarily know to do that. What is the benefit of having it as an opt-out system?
Please go ahead.
Mr. Chairman, Representative, we are within different subcommittees of the legislature talking about with WDE mental health screenings for the first day of school for K through 12. And part of the reason we are doing that is to have that data, to have a baseline data of what our mental health looks like for our K through 12 students, being able to track that over years, being able to also then inform parents with that similar screener if there is a change, and raise the red flag. As of right now, we have no idea what that looks like, is in the very early stages of that discussion. If parents opt out of that, you will have incomplete data. You will have kiddos that are not being monitored. You will have kiddos that fall through the cracks. And though, yes, parental rights, parents have the right to opt out of that. What we also saw in COVID is that school districts and schools are foundational in catching those red flags for our kiddos and getting them their needs met when parents who may not recognize that red flag or may not know it's there.
Representative Berger has a question. Go ahead.
Thank you, Mr. Chairman. Thank you. In your professional opinion, do you think that if we just don't talk about gender identity and don't teach about it, that the bullying should go away in schools? And do you think that it'll just magically just go away? We don't talk about it?
Go ahead, please.
Mr. Chairman, I'm going to answer this as a mental health professional. I have found that anytime information is not given to a person, whether that's information about a suicide lifeline, information about possible community services to meet their physical needs, information about sexual orientation, and gender identity, that harm to that person increases across the board for any issue. Information usually de-escalates a person who is in mental and emotional crisis. And so if by not talking about it, bullying will decrease, our kids are going to be safer. I would argue that the opposite will happen, that by pretending that these things are not within, that are not existent, we will actually be putting our kids at risk because they will not have adults to talk to.
Follow up? Real quick. Thanks, Mr. Chairman. So, I mean, the same kind of goes for not talking about drugs, right?
Correct.
That drugs, I mean, we should have drug education. Say no to drugs, right? Or just don't talk about it and kids won't do drugs. Is that, I mean.
Mr. Chairman, Representative Berger, absolutely. A really great comparison would be hunter safety. We are not hunters. We very much rely on my dad for all meat since he's a rancher. However, I very much want both of my children to be educated in hunter safety because the knowledge of a gun and how to handle a gun is going to increase the likelihood that if ever they're hanging out with friends, if ever, who knows what happens. We do hear about friends accidentally playing with a gun and a firearm going off. Hunter safety for me is a non-negotiable as a mother within Wyoming. And just because we may not use them does not mean that education should not be there. It absolutely increases safety, and I think it would increase safety for our LGBTQ kids as well, to just let them function in the space that they're already in.
All right, thank you. We'll have 4 more that are for the bill. And then we're going to go online. Welcome. Somebody started off. Great.
Chairman, members, thank you for having us. My name is Ruth Ann Hubbard. I live here in Laramie County, north of Cheyenne. We moved here, chose to move here 34 years ago and raise our 5 children in Laramie County School District 1. The reason that we chose to come to Wyoming was because of the school system. We had job offers throughout the Intermountain West. And the most important factor for me as a mother of 5 was the educational system. With that being said, one of my 5 children was diagnosed with a mental disorder at the age of 8. He was diagnosed at that time with what was called a mood disorder. They don't diagnose them with anything more definitive than that until much older. What I appreciated about being here in Wyoming is that I was very much kept in the loop. He had several instances at school in elementary and in junior high where the school would call me and not take it upon themselves to send him to a counselor or find out what was wrong with my child. The thing that I appreciate very much about this bill is that it keeps parents in the loop. To me, the foundation of our society is the home. No matter how that home is situated, no matter what's inside that home. I take my responsibility as a mother of 5 and a grandmother of, believe it or not, 22 as a sacred responsibility. And as you can imagine, with that big of a family, I have every aspect of the spectrum and every situation you could possibly imagine in loving and caring for those special individuals. I have my oldest grandchild is gay. What we appreciated about being here was the fact that we worked hand in hand with the school to be able to help him. He didn't worry about being called by a certain name. He knew he was a him, but we worked together as a family. To me, the family is where you raise and educate your children on morality issues, on religious issues. And the school district, the government, supports the family, not the other way around. So I believe that this bill is instrumental in reserving the rights of the family, keeping parents in the loop who have that sacred responsibility to nurture and raise children in a loving and supportive environment. Any questions for me? Thank you.
Secretary of State Chuck Gray walked in.
How you doing, Chuck Gray?
Okay.
Mr. Chairman.
Thank you, and recognize Representative Trujillo's here.
There she is, Representative Trujillo. Yep.
Yeah.
Thank you. All right, please continue.
Mr. Chair and members of the committee, my name is Donald Career. I am a Cheyenne, Wyoming resident, pretty much born and raised here. I support this bill. And I, sitting here listening to all the testimony, we've had some amazing people in here, no matter what side you're on. One thing that I'm going to say before I even really get into what I really want to talk about is that we're adults, and a lot of the time that we see in these communities, they're going to mimic what these adults do. I've seen a lot of hate on both sides. I've seen a lot of arguments. I've seen a lot of careless behaviors out there that puts a lot of people in jeopardy, no matter where you stand, no matter what your sexual orientation is, you're religious. This is the real world that we live in. And I don't think sitting around and kind of catering to these certain things are going to do anybody any good. There's kids that get bullied because they're Christians at school. I don't see anybody, up in here, raising up arms because they're Christians. We've heard testimony that there's been kids in here that come from, a family that has two fathers. Again, I think that the bill I think it's pretty clear. I don't think that anybody's arguing that a teacher cannot say or acknowledge that they have two fathers. I think the point is that we're not teaching sexualization to kids that are barely understanding what the color blue is. I think that goes back. I think that we have honestly heard both sides make a very compelling argument that it should be for this bill. I've heard some of the teachers and some of the parents essentially say that on a professional level, they wouldn't even acknowledge it. So I'm not understanding where the confusion is at. Another thing that I want to point out is teachers are here to teach the basics, the reading, writing, arithmetic, et cetera, et cetera. What I don't hear and what I don't see, no matter if you're a teacher or not, is when did we assign teachers to be counselors, child psychologists, behavior specialists? They're not. That's why it goes back to the parents. Let the parents decide what they want to do. Another thing that I haven't heard is lawsuits. If you have a 40-year-old man sit there and talk to a 12-year-old girl about her sexuality, you better believe a parent's going to be upset about that. What is a man doing that? If we see an adult teacher go to a young boy and open up a conversation because that boy has a fantasy of a hot teacher, are we prepared to start seeing the legalities come from that? Because when we open up Pandora's box and we say that this is just open, then we open that for everything, no matter what side you're on. And I don't understand that, everybody here is saying that they have concerns for their children, and everybody's worries and fears should be acknowledged. There is nothing wrong with saying, I oppose the LGBTQ system, or I oppose this. We need to stop demonizing each other just because we have opposing views. I don't agree with it. Personally, I think it's just like what it's been for a lot of time in this nation. It's been considered mental health. When are we going to have the mental health professionals? Recently, I've had the honor to be in friends with Scott Nugent. I don't know if anybody's aware of Matt Walsh's documentary, What is a Woman? I would like to actually see some trans people get in here and give us some facts. What's their testimony? Because I've heard a lot of what ifs. I've heard a lot of, well, hypotheticals. Well, we're not dealing with hypotheticals. We need facts. Otherwise, we're just going to cheat and rob ourselves of it. I think that we should vote for this bill. I think it's good. And I'm open for questions. Thank you.
Anybody? Thank you, sir.
Good afternoon, Mr. Chair, Co-Chair, and committee members. My name is Carolyn St. John, and I'm happy to be here today to testify in support of this bill. I'm a grandmother, an adopted grandmother of 2 grandsons aged 8 and 10. I moved my family to the beautiful state of Wyoming in 2021. We are happy and proud to be new residents of our community in Sweetwater County. I often jokingly refer to my family as California refugees. I could not, but the sad truth is that I could not, in good conscience, continue to raise my boys in a school system that has strayed from basic academic merit-based instruction to promote ideologies based on personal feelings and desires without moral boundaries. This parental rights bill is not an attack on any type of personal sexual preferences or orientation. It's simply a common sense solution to prevent exposure of sexual content to children who are not yet developmentally ready to process explicit information and to codify the God-given right of parents to raise their children. Unfortunately, Wyoming is not in a vacuum, and just as the current issues are now of immigration are now affecting all U.S. states, we cannot afford to turn a blind eye to the progressive ideologies that are sweeping across our nation and through our school systems. This bill provides essential protections against indoctrination and early sexualization of our kids through transparency in the public education system. It empowers parents and protects the nuclear family. This is an important step in the preservation of personal freedoms, and I implore you to pass it. I stand for questions if you have any.
I have questions for Carolyn. Thank you very much.
There we go. How you guys doing today?
Good.
Yeah, my name is Brian Pixley. I'm a resident here. I've been born and raised here in Wyoming all my life, and I'm a married father to a very nice, awesome wife, you know, who has artistic kids, and my 3 grandkids go to this school district that are artistic and, you know, and very special needs people, you know, and I'm for this bill. You know, it's like, well, what if a teacher comes up to my granddaughter or my grandson that's just little Connor or Daniel or my 18-year-old granddaughter Chloe, you know, a lot of them have special needs, you know, and but a teacher comes up to them or student or comes up to them and says, you know what, how would you like to, you know, have sex or whatever, blah, blah, blah. And they're going to be like, what? You know, and in other words, I wish this should be up to the parent to teach the kids, not the school district, you know, it should be up to the parent. It's like the old saying is like the birds and the bees. You know, the parents should be the ones that say, hey, let's have a little man on man or woman to woman talking. Let's get this over with, you know. So I'm for this bill. And I'm up for questions.
Thank you. And actually, this would probably be for any one of you 3. And I've heard it a couple of times today, and so I guess I've been kind of biting my tongue on whether or not I wanted to bring it up. But have any of you ever heard of the term in loco parentis? Okay, so in loco parentis is basically what we look at when we take our kids to school. And what it is it's a Latin term that says in place of a parent. And it actually requires that a teacher, a teacher's aide, principal, janitor, anybody in an authoritative state that has control over a student in education, that they would act in a responsible way that any prudent parent would in place of a parent. So that's where a lot of this comes down to. And I actually just learned this, right? So my wife is a school nurse, and I actually was just, interestingly enough, given this information 2 days ago, where the school nurses from across the state are meeting just outside here at Little America, and they gave me some of their feedback on this bill. And their immediate reaction was, we don't need this because so much of this is already done, right? And so to your point, as you were just saying, you actually believe that the school district is doing a good job giving you the information that you need when your kids are there. Is that right?
Not all the time, because like when my grandson gets sick or whatever, they don't call us or notify us or nothing. So they're very kind of low key on it, to where they notify us of like our grandkids being sick or anything else like that. You know what I'm trying to say?
Follow up on that. So let me ask you, maybe in a different format then, do you have custodial authority of your grandchildren?
No.
So then there would be no reason for them to tell you as the grandparents. Do they keep the parents informed though?
Yes, they keep the parents informed, but I know I kind of distribute to the parents, to say, hey, I don't want my kids being taught this, so.
Sure. So last question on this, Mr. Chairman.
Sorry about that.
Go ahead, have a nice conversation.
Mr. Chairman, thank you. I guess what I'm ultimately trying to get to on this is, I've actually heard it from the pro side of this bill a couple of different times today, that they feel that actually the school district has been good at informing the parents of the things that have happened. Now, I think we're all aware of the one case that has made the news in which the parents were not made aware. Things have boiled over, and we're seeing the repercussions of that, right? But I guess ultimately my question to any one of the three of you is, have you had an interaction with the school district in any way, shape, or form in which they have withheld parental information from you when you've requested it?
Can anybody answer that?
Mr. Chairman, I have not had that experience personally, as my grandsons are currently enrolled in a private Christian school. However, that school only goes up to grade 6, and I have concerns. And I believe that this bill would put in good boundaries, to have good boundaries in place before we have to address those issues.
And thank you for your time. Thank you. Yeah, I appreciate you.
Mr. Chairman, if it's okay with you, I'll just let all 3 of them in right now and then, okay.
Well, thank you, Mr. Chairman. Appreciate it. Thank you. Well, I'm happy to adhere to that, and it'll be less than that. I just want to say I'm very in support of this bill, very concerned about some of the national education trends, and I think we need to get ahead of some of these trends coming to Wyoming, and I think we've seen some cases where, unfortunately, some of these trends have come to Wyoming. And in the Wyoming Secretary of State's office, we're one of the main agencies interacting with business, and wholesome education is pivotal to having a workforce that is going to promote business in our state and continue our core industries that are pivotal to our state. And I also think about these things on our role on the State Loan and Investment Board, the State Building Commission. So I think this bill is very important, very in support of this bill. We need to make sure that the woke ideology does not come to Wyoming schools, and some of the instances where we've seen it, in the one in Sweetwater County, and we need to make sure that we protect our state. We need to focus on reading, writing, arithmetic, real enrichment, social studies, promoting our values, our true history, and this gender ideology that is being injected into our schools, extremely damaging the future of our state, the future of business in our state. And I think this bill, passing this bill is pivotal in promoting our values. That's all I want to say.
Good job. Thank you.
Thank you.
Mr. Gray. Anybody have questions for Mr. Gray? Thank you for showing up.
Thank you. Thanks for your time.
All right. So we're online.
Miss Willie, whenever you are ready.
Hi, everybody. Sorry about that. I had waited as long as I could, and I've got to get one of my kids to football practice. So
It's life.
my name is Ashley Willie. I am a mom to 6 beautiful children. I am a wife, and I am a teacher in Rock Springs, Wyoming, and I teach for Rock Springs Junior High School. I am absolutely in favor of this bill and wish that it had gone through the first time that it was brought up instead of waiting because people said that it was not in Wyoming, because it is very much in Wyoming. Some of you may have heard some of our story. Quick recap. I have a now 17-year-old child who was attending school here in Rock Springs, Wyoming. This child was given this child was given communication to hide things from me, her mother, my husband, and our family. She was encouraged by people who are supposed to educate her on math, reading, writing, social studies, that lying to her parents was appropriate and acceptable. Creating a rift between her and our home. This is not the place of educators, and I say that as an educator. As an educator in this district, I pride myself on making strong connections with my children, my students. They're not my children, with my students. And they know that I am a place that they can come to, but I am not their parent. I will support them all the time, but I am not their parent and cannot make decisions for them. My child was given counseling to help her work through these problems that she was having without my consent or knowledge, creating further confusion in her when we already had things in place to help her that nobody bothered bringing up. My child, all of my children are my children. They are not the state's children. They are not the school's children. And the fact that somebody encouraged my daughter, who I have raised from the time she was little to now, to be dishonest to the one person, the people that have been there for her entire life, is appalling. It was not because there was danger in the home. If there was danger in the home, as teachers, as a teacher myself, I am a mandatory reporter. This has got to stop. I am my child's #1 advocate. I love her and support her through everything. And I am the one that is going to protect her in everything, not the school district. This bill is not about blocking me as a teacher from addressing things that have been mentioned. Bullying. I address bullying all of the time. If a student brings something up, I say, listen, guys, everybody's different. In this great country that we live in, we are allowed that freedom to be different, and we need to respect that. We do not have to agree, but we do need to respect that. Nothing in this bill prevents me from having that conversation with students. It does, however, prevent other teachers from imposing their will and their beliefs onto my family and my children. If I don't want my children to have discussions about this, that is my right as their parent. And when they grow up and turn 18 and decide that they want to have these conversations, they are able to do those things. If they come to me and want to have these conversations, then I, as their parent, will facilitate this conversation in the safety of our own home. And we will talk about all sides and move forward from there. But it is not the school districts or the schools' responsibility to teach this to my children. And I'm here for questions if anybody has any.
So anybody have a question for Ms. Wiley? None appearing. Thank you very much for taking time for us. Thank you.
Mr. Winnie, whenever you are ready.
Mr. Winnie, are you on?
We also have Kelly Bridges, so if you want to hop on while we're waiting for Mr. Winnie to be ready.
Yes, thank you very much. Hello, my name is Kelly Bridges. I'm a mother of young children and also happen to be an attorney. It's very difficult to follow Miss Willie there, but I think that her concerns and thoughts on this subject represent those of the majority of Wyoming mothers and parents. And I think she really needs to be listened to, and a cautionary tale of what could happen if legislators, school boards don't take these issues seriously and try to address them before they become ugly issues. Certainly someplace where the legislature could step in and should step in. Anyways, I would like to take this opportunity to thank Senator Beitman for reintroducing this very important bill. The parents and community members that I know and whom I speak with, which is quite a few, support this bill. I've been listening to this meeting all afternoon, and as a parent, I'm struck by how concerned our administrators, agencies, and teachers are about our children's sexual orientation and gender identity. School sounds like a mental health facility, not a place of academic instruction. There has been little to no discussion of actual academic instruction today. That is what this bill deals with, academic instruction. Parents whom I know do not want school to be about reading, writing, and arithmetic. I've heard other parents express that today. Parents do not want, to quote, everything to be interwoven, as the teacher stated earlier today. In fact, they want it to be kept separate, precisely separate. That is for them. Parents don't want teachers speaking to their children about their gender identity or sexuality. Heck, look at the news. People don't even want it in their beer. They certainly do not want it in their child's classroom. If there is no instruction on sexuality until 8th grade in Wyoming, as was said earlier, then let's keep it that way. A vote for this bill would affirm that. If schools are already keeping parents informed, as was previously suggested, which I know is not always the case, however, then why not reinforce that with legislation like this that affirms what they are already doing? There has been quite a bit of misguided legal analysis today as well, with regards to the first section of this bill. The speech and expression of teachers may be restricted by the state as it implies to scope of employees' duties, and a school may demand that instructors limit their speech to topics germane to educational mission. There are several U.S. Supreme Court cases which support this. See Garcetti v. Caballos and Pickerling v. Board of Education, in addition to the previous cases that were cited by Mr. Beitman earlier. I would also like to address what is the supposed concern by one of the speakers, that there are concerns this is an out-of-state issue that does not belong here. Well, they most certainly belong here because precisely due to out-of-state influences, which include curriculum that comes from Denver, Portland, and the East Coast that do not reflect the values of Wyoming. This is what our schools teach without anybody questioning it. Further, teachers attend trainings from out of state, which further reinforce values that are not traditional Wyoming values. Those are the out-of-state influences that legislators should be concerned about, not about this bill. Thank you.
There we go. Thank you, Kelly. Okay, Mr. Winnie, you're up.
Okay, I'm up this time.
Can you hear me?
Yes, sir.
Okie doke. My name is Bill Winnie. I'm Sublette County, speaking for myself. Across my 30 years of active duty in the Navy, I led a number of sailors on a nuclear submarine. The average age was probably about 19 or 20, and it was all men. Late in my career, I commanded a ship with a crew of 13 to 1,500 men and women. Average age there was about 18 and a half to 19. So I was essentially dealing with high schoolers. My wife was a career educator, and as an aside, one time at a dinner table, I happened to remark that my young people on my ships were pulling the same kind of tricks and stunts that hers did. It's just mine were a little bit more experienced and slicker about it. The core issue that I feel your committee is facing is very simple, but difficult to deal with. When does one cross over from projecting behavior onto kids or proselytizing kids? That's the thing you're trying to struggle with. My experience says leave kids alone. They'll figure it out. It may take a while, but they'll figure it out. When you get questions as an adult, in this case, a teacher or maybe some other adults in the school system, you give them a truthful answer, but you keep it short. Kids will deal with what they can at the time. If they're not mature enough, they put it away in a corner and they take it out later when they are mature enough. How did I handle things with those young people on my ship? Very simple. I enjoined them to be professionals. When they came across the brow onto the ship, I expected them to be professionals. Well, what's a professional? A lot of things about the specifics of their job, but it also included being courteous and respectful. One of the things I used to say was professionals disagree. Professionals should disagree professionally. So, what are you dealing with? Well, the First Amendment, in my opinion, does not apply to the teacher-student relationship. What you have is teachers have to be truthful and speak to students and answer their questions, but they cannot transgress into the parental authority and responsibility. And as an aside on that, Representative Brown spoke to loco parentis, and I think he kind of mushed a couple things about it. Case one of loco parentis is you have a child that is severely injured and requires immediate medical care. Of course, you do what it takes. The other case is much longer term. In this case, we're talking about children that are growing up, maturation. And like I said, the adults in the system should speak truthfully to them, but they should not go beyond that. They have to leave to the parents in the home what belongs to the parents. Subject to your questions, thank you.
Thank you, Mr. Winnie. Anybody have questions? Go ahead, Representative Clauston.
Thank you, Mr. Chairman. Thank you, Mr. Winnie. Ken Clauston, Representative. So just want your opinion on how you feel about this bill and the need of it. I'm reading page 7, lines 17 and 18. It says, this section shall be implemented by each school district in accordance with Wyoming Statute 14.206. Interesting enough that Wyoming statute became effective July 1 of 17 is read, protection of parental rights. The liberty of a parent to care, custody, and control of their child is a fundamental right that resides first in the parent. So that passed 6 years ago. So your opinion on this bill in front of us, are you thinking this is something you're in favor of, that we need to pass? Or do you feel like we're handling things appropriately at this time?
Go ahead, Mr.
I support the bill. You run into the issue of how do you apply the standards. The legislature can apply standards, the superintendent of public instruction, and the local school boards. And where do you cross over with those standards to, as I mentioned earlier, the issue of projecting or proselytizing? And that's really the core you're trying to get at, is where is that line where you would cross over? Because crossing over transgresses clearly on the parental rights and authority. You had one other speaker before me speak about a school system that told their child not to say things to them, to the parents. Come on, that has no place in the system. And thus I believe the bill may need some work. That line between proselytizing and projecting and just answering the question is a fuzzy line, but I support the bill.
Further questions for Mr. Winnie? Thank you, sir. Appreciate your comments. And with that, that closes up public comment.
Mr. Chairman,
Go ahead, Representative Lawley.
I'd like to make a motion that we move the bill forward, but with amendment that I would offer at the appropriate time.
Mr. Chairman,
Yes, Chairman Scott.
Mr. Chairman, I would urge respectfully the representative, let's just move the bill forward and do the amendments at the next meeting when we can have them properly prepared. Now, I think that we may split the bill in two. I would hope you would give the chairman latitude to do that and to make sure that we're within our charge as a committee. Because I think on half it, we may be trespassing outside it.
I think that's what the intent was of the motion.
Oh, okay.
Yeah.
But
Yes.
So there's a motion on the floor.
Yeah.
There's still a motion on the floor. It's been seconded. All right.
that's good. Okay, that's good.
Okay, discussion? Anybody? Go ahead, point of order.
So this is just to make sure that everybody's clear here as well as out in virtual land and everybody here. We're now moving the bill forward, not to the next meeting, but to sponsor as legislation.
No,
It-
next.
Okay,
To the
that
next
was not
meeting.
the motion.
That was not.
The motion was I'd like to move the bill. And the motion to move the bill, it means that we are sponsoring. So I think we need to correct the motion if that's what we're intending to do.
Go ahead and restate your motion,
Yeah.
please.
Again, the motion was to move it forward to the next meeting, subject to an amendment at the appropriate time. That was the motion.
Representative Provenza.
Thank you, Mr. Chairman. All these people came out today. We heard all this testimony. We're going to come back in November and we're going to remember everything that we heard today. We're going to know exactly what to do with that. And we're not going to hear it again. People are going to just not have anything else to say about it. And so we're going to act appropriately and not spend another full day on this, Mr. Chairman. I'm very concerned that that is not at all going to happen. That won't be the reality. And I did come here to work today. So I would like to work this bill.
Motion that's on the floor. I think we would not do good work if we tried to work the bill today for a couple of reasons. One is simply the hour, and I think everybody is weary and we don't do good work under those circumstances. Second, there have been quite a bit of talk about amendments. I would want time to have those people to digest what they heard today, write careful amendments, and run through the LSO, anything that's complex. So we have something firmly in front of us. And I think for both those reasons, we need to simply carry it forward. And I do think we're going to need the latitude to say there's a piece of it that's outside our charge.
Go ahead, Representative. I'm sorry, Senator.
Thank you, Mr. Chairman. And I guess we'll have to see how the rest of the motion goes with the amendment. And I have some suspicion of what the chairman's interested in. The concern I have, and I share Representative Provenza's concern, is we spent most of this day on a topic that wasn't one of our interim topics at the expense of mental health, which we dropped from the agenda. When we raised this at the last meeting, my concern at that time, when I objected to bringing it to the next meeting, was that we would spend the entire day talking about this and only this, the first 10 lines of this bill, which were outside of our purview with regard to our interim topics, and that we wouldn't have time to talk about substantive issues, which are within our purview. So here we are. Mr. Chairman, the concern I have is if we simply push all of this down the road to November, we need to, it is a directive from Management Council that we listen to public testimony, and we will once again spend the entire meeting listening as is appropriate, because believe me, I wouldn't want to hold anyone back next time. I would want everyone back, everyone showing up, everyone providing public testimony. But we do that at the expense of the work that we need to get done related to education in the state, and particularly our priorities in the interim. So I'm interested to hear Representative Lawley's proposal on perhaps that division in the amendment and what Mr. Chairman is talking about, but I am not eager to move the entire bill to the next meeting, because I would prefer to get back to work on the topics that we haven't really as prioritized through the Management Council by this committee that have been approved topics, which is not what we're considering.
Anybody else? Go ahead, Representative Brown.
I'd say not only ditto to that, I'm actually just more in the motion of, we've had this bill not only last session, but we've also had this bill sitting in front of us now for going on 3.5 weeks. In my opinion, it was incumbent upon us as legislators, knowing that we had a bill coming forward to this meeting, to have amendments drafted or ideas. And frankly, to be honest with you, Mr. Chairman, I've got plenty of red markings ready to make my amendments. And I think that if we have an interest in moving this bill forward, make an amendment to cut the bill out, as we're planning on seeing, make that another amendment and draft that other bill. But I think that we did come here, and I think all these people came here expecting us to make a motion not to punt this down the road. I think that this has been in my opinion, I'll just speak straight from the cuff here, what a waste of time. If we sat here and listened to everybody to punt this down the road, one way or the other, I don't care which way it goes. But what an extraordinary waste of legislators and public's time to not work a bill and to punt it down the road when we already have the fresh information right here. Changing this for another 1.5 months is not going to change the outcome of whether or not this bill moves forward.
Co-Chairman Scott.
Mr. Chairman, I'm going to draw on my years of experience as committee chairman of various different committees. We have found over the years that hearing the testimony, having some time to think about it, having some time to draw the amendments properly, gives you a much better product. And I think that's what the motion before us is seeking to do. And well, I would urge us to adopt that, because I think we will cease to do good work if we don't.
I'd like to hear the amendment.
Again, the motion envisioned that, the committee would decide when the appropriate time to bring the amendment is.
Sorry, I can't hear.
I said the motion envisioned that the committee chairman would determine the appropriate time, or we as a committee, to when to bring the amendment. And I think there's been persuasive comments made, Mr. Co-Chairman, concerning whether at least something significant that we've already alluded to about whether there's a part that should be set aside for a separate bill. I don't know that that requires a lot of thinking about it. I've been thinking about it for 3 weeks.
3 weeks.
Mr. Chairman.
Go ahead, sir.
I thought that was part of her.
If you have to vote on the original motion to do that first.
Mr. Chairman, can I make the amendment then, or go ahead and motion to move the amendment? But my problem with this is it's not really an amendment. It's a motion on the floor to delay this bill to the next thing. And I think the motion is then going to be, from that point, to separate this into 2 bills.
Yes.
And so I'll make that motion. I'll make the motion right now on top of the current motion that's before us as an amendment to separate page 2, lines 4 through 20 as a separate bill.
Second.
Okay, it's been moved and seconded as an amendment to separate out page 2, lines 4 through 20. Discussion. Anybody? Yes, Senator Office.
Yes, Mr. Chairman, I just would say that you'd have to provide flexibility for conforming.
Sure, yeah, yes.
Which I think is obvious. And then, Mr. Chairman, are we going to do, I think it's unclear from the structure here what then happens next. If the intent is to remove that portion and not forward to the next meeting, perhaps we just make a positive motion of what people want to forward to the next meeting and see if that survives. That might be a cleaner motion. And then if there needs to be a second motion, that would be reasonable.
Was there? Yes, there was.
Mr. Chairman, and Senator Office has confused me a little bit. I'm thinking that the motion was to separate out the page 2, those particular lines, and then there'll probably be a follow-on motion to carry the balance of the bill forward.
Isn't that your intent was to take the other way and say, this is how much of the bill we like and move forward with that, right?
It might be the same. I'm not entirely sure. Let's find out.
Well, we have a motion on the floor and an amendment. So we have a motion on the floor.
Let me do this. Can I withdraw my motion? Can somebody withdraw their second?
So, Mr. Chairman, point of order. We actually do have, we have 2 motions on the floor, which legitimately mine was out of order, right? So we do have a motion on the floor from Representative Lawley to move this bill forward. And I think at that point, the idea really resides within your prerogative as chairman. I think you can direct LSO at that point to say, split these into 2 bills if that's what you would choose, or we can do that at the next meeting and split it into 2 bills. But as it stands right now, the motion on the floor was to just move this forward as is.
Right, no, that's, again,
an unknown
amendments
amendment,
at the appropriate time. And I think the confusion is over when the appropriate time would be, now or at the next meeting. But I think it might be easier for me to withdraw that motion. And the second, from Representative Clauston. So I withdraw that motion. So let's.
Who's on first, Mr. Chairman? Okay. So, Mr. Chairman, with that being withdrawn, I would motion that we separate on this draft legislation, 24 LSO 0076, that we would create a new bill out of basically page 2 down to line 20. And then it would also have conforming amendments for the enacting timeframe. So this would, I would just trust LSO to make sure that they know what we're doing with that. The remainder of this bill at this point would be everything else, and that would remain the current draft legislation of 24 LSO 0076. But this would create 2 bill drafts.
Seconded by Lane Allred. Any discussion on that? Go ahead, Representative Provenza.
Thank you, Mr. Chairman. I guess one of the points I'd make, and going back to constitutionality that we discussed earlier, is we've got 2 subjects in this bill, and I think this cleans this up so that we can take out at least one of the many constitutional concerns. So I would support this motion.
Okay. Anybody else? If not, I'll proceed to vote. All those in favor signify by saying aye.
Aye.
Those opposed? Right. The motion passes.
Mr. Chairman,
Mr. Co-Chairman.
move we carry the balance of the bill, the old bill less the piece we've just taken out, forward to the next meeting.
You make a motion?
And that's we want to just do it without a motion. What's your preference?
Go ahead, Mr. Representative Brown.
Mr. Chairman, the reason I voted against my own motion is basically because I felt the feeling of the committee was to have this into two bills, right? That's the reason I made it. I was against it because I don't want to see it move forward. The committee voted in favor to split these into two bills, which would then mean we need to see these two bills at the next meeting regardless.
No.
We just divide them.
Just divide.
Divide and conquer.
What do you mean divide and conquer?
Mr. Chairman, let me see if I can express where I think we're trying to go, is to take the balance of the bill, which is less controversial, but still quite useful, and carry that forward. That does not have it's outside of our charge problem to it. It doesn't have the two subjects problem. So we need to carry that forward. Then we have the other one, and the question is, should we carry that forward? And I would say we ought to just not have a motion on it and give the chairman discretion to exclude it, and we probably would for being outside our charge. Mr. Chairman, if that's acceptable.
That's acceptable. Senator Rothfuss.
Thank you, Mr. Chairman. What we've done so far is we've divided it into two bills. Each of those is separately actionable. If somebody wants to make a motion, which is what I believe the chairman is doing on bill number 2, which is the second half of the bill, I think that's what the chairman is saying. He wants to make a motion to move that to the next meeting. That is in order. The first bill then is up in the air. It could be moved to the next meeting, or it could be intentionally tabled. Personally, I'm not satisfied with just leaving it alone and having it show up on the next agenda. I would like to dispose of it now because I don't think there is the support, and I think we're better off making it clean that we're not talking about it because it's out of order. But that's a separate issue. So right now, the motion on the floor is to carry forward the second half of the bill, which I believe is the motion the good chairman made.
Second.
The second half of the motion, or the second half of the bill. Any discussion? Not appearing, we'll proceed to vote. All those in favor signify by saying aye. Aye. Those opposed? All right, let's deal with the first half.
Mr. Chairman, I think we've got two choices. You can either make a motion, or frankly, if you leave it up to me and Chairman Northrup, my recommendation to Chairman Northrup is that I think it is outside our charge. And while we've had testimony and learned a lot about what ought to be in a second bill, a private bill, which I would certainly support, I don't think it belongs on our agenda because I think it is outside when we've heard all the things we have on it.
Representative Provenza.
Would it make sense then, Mr. Chairman, if I motion to decide not to sponsor that first portion of that bill at all by this committee, so that there's no question?
So there's no question, I would agree with that.
Mr. Chairman, if the motion is simply to not carry it forward to the next meeting, that would, I think we can just dispose of that with a voice vote. If that's the way you want to
Is
handle
that
it.
your motion?
Yeah, I want to just make sure it's done.
Okay.
It's not a table.
We have a motion to move the bill to the next, to not move the bill to the next meeting. Go ahead.
Negative motion, okay. Is it appropriate to call a roll call vote since we're finally dispensing of a bill? That way we're all on record on how we're voting on that. Is that appropriate?
Understand.
I would make that
Second on
motion.
Okay, it's been moved and seconded to not move the page 2, lines 4 through 20 forward. Any more discussion?
Mr. Chairman,
Go ahead.
if we're going to have a roll call, which I didn't think we were going to, but if we're going to, I want to make it very clear, I will vote no, although I am a supporter of the contents of that bill, but I think it will have a better chance of passage if it is a private bill, and if it is clear that some of us in the committee voted against it as a committee bill because we thought it was outside our charge from the management council. And I want to make that very clear.
Okay, further discussion? Representative Provenza.
Just point of clarification, so because it is a negative motion, voting aye means that you're supporting not taking it, that it's not a committee bill. So you vote aye if you don't want this to be a committee bill. You vote no if you want the committee to sponsor this, the first portion under paragraph A.
Correct. Any more discussion? All right, proceed to vote. Roll call, please.
Mr. Chairman, on the roll call vote to not forward the first part of LSO 76, page 2, lines 4 through 20, Senator Beitman,
No.
Senator Brennan,
No.
Senator Rothfuss,
Aye.
Senator Steinmetz is excused, Representative Allred,
Aye.
Representative Andrew,
No.
Representative Berger,
Aye.
Representative Brown,
No.
Representative Clausen,
No.
Representative Lawley,
No.
Representative Overmuller is excused, Representative Provenza,
Aye.
Co-Chairman Scott,
Aye.
Chairman Northrup.
Aye.
Mr. Chairman, you have 6 ayes and 7 noes,
All right,
so you will be seeing this.
we'll be seeing it again. Round 2.
I guess my question on this is, we just voted
To not.
to not sponsor something. So does that in effect mean we are voting in effect to sponsor something?
No.
So I don't think we will be
That
seeing
was not the
this.
motion.
Yeah, exactly. So I think if we want to see this, there needs to be an affirmative motion to sponsor this bill.
Mr. Chairman.
Yeah. Senator Biden.
Wow, we do great work after 5
no.
o'clock. My apologies to everybody that's watching. We're not normally this dysfunctional. So with that being said, now that we have 2 distinct bill drafts, one is already going through to the next meeting for amendments and to be worked. I'm assuming this one is not, although it's out there. I will make the motion to move this to the next meeting and allow us time to draft amendments to tighten up the language that was discussed today. We heard a lot of testimony on what instruction means. That gives us time between now and then to have a good bill draft that we can vote it up, vote it down for the next meeting. I will make the motion to carry this on to the next meeting, just as we did the previous bill.
Okay, it's been moved by Beitman, second by Ocean Andrew, Representative Ocean Andrew. I mean, you mean you want to vote or you got a question? You want to vote? Okay. All those in favor of the motion, please say aye.
Aye.
All those opposed say no. No. All right. Division. All those in favor, please raise your hand. I have 4. All those against the bill, please raise your hands. 7. Okay.
Can I just make the motion that nobody else seems to want to make, and we'll just do this? I don't know how we actually do this because we don't have the legislation in front of us, right? I think that's the hardest part that we're struggling with right now, is we have voted to split these. We know what it's going to say, but nobody wants to just vote on the motion. I would just move that, I know how I'm going to vote. I would move that we sponsor the piece of legislation that we have struck out pages page 2, lines 1 through 20, to be sponsored by the Joint Education Committee as a separate bill.
We just,
I see some questions. So my motion is, it seems like we've talked ourselves around, right? We voted to not, then we voted to not move it forward. So we just have a bill just kind of sitting here, not doing anything. I'm making a motion so we can just decide whether or not we're going to see this again, period. Just make the motion to vote it up or down right now.
To sponsor it.
To sponsor it as a committee bill.
To send it to the
That's all I'm doing.
To send it to the budget.
We know what it says. It's that plus the conforming amendments is what the motion would be. That it would be page 2. That is we'll just call this the classroom instruction portion of the bill, plus an enactment clause, plus the date of July 1st, 2024.
So the issue I have with that
Give me
is
a
that,
second.
yeah,
Second
okay.
for discussion.
Okay. Good. Ocean gave it.
okay. Good.
Well,
Representative
my
Lawley.
concern is that Senator Beitman mentioned changing language, tightening it up, and those things might make a difference for me about whether we sponsor it or not. And so a bigger step than we were taking on the substance, the remainder of the bill, which I have much more clarity about and support and want to see as a committee bill. So I feel we've kind of stepped over a little bit of a line there, but that's just my view.
Mr. Chairman, just as a point of clarification for staff, the motion is to sponsor a new bill, whatever it is, 76, we'll call it -1, that would include lines basically 6 through 19. That the Joint Education Committee would sponsor that bill, would not be presented at the November meeting, and the contents would be as contained on 76 as it currently stands. Thank you.
Thank you, Mr. Chairman. On and against the motion. We put in all this work today. We've heard testimony. It's not going to take much to get to what people were asking for on tightening up the language of instruction. If people don't trust the language that's in the dictionary about what instruction means, we can get more specific. And we can put sideboards on it. We can say what it is and what it is not. And then we'll have a bill to vote up or vote down. But right now, the public doesn't even know what we're voting on, and we're voting on whether or not we're going to sponsor a bill. This is bad business. We need to quit while we're ahead. We need to go home and go to bed. It's past our bedtime. Vote this down. Let's continue and do good. Come back tomorrow and do good work.
Mr. Chairman.
Representative Brown first.
So, Mr. Chairman, the only reason I made this motion is because we have failed twice on previous motions. One was to move the bill forward and work on it. That failed. And then there was another motion to, I don't even know how we did a negative not motion, but ultimately all I'm trying to do is make it clear that if we want to see this bill one way or the other, it's either coming from this committee or it's coming from an individual. We have already spoken saying this committee does not want to see this in the next meeting. That was the last motion. So now all I'm trying to do is come back and clean up with the vacuum here and just say, okay, is this committee want to sponsor this bill as is? And if that answer is no, vote against my motion. And then that sends a clear directive to whomever wants to sponsor this bill as an individual. Bring it as an individual bill, but this committee will not be sponsoring page 2, lines 1 through 20. That's why I'm bringing this motion.
Further discussion? All right, we'll put it up to the call.
It's a roll call.
Mr. Chairman. It is a roll call. I will explain because I am in favor of the substance of the bill. I'm going to vote aye on the motion, even though I don't like the thing of doing something outside the charge of the Management Council. this motion is on, will we sponsor something, which is something that I do support, so I will vote aye.
Well, I support it also. However, management did tell us not, so yeah, I'll vote the other way. Go ahead, Senator Biden.
Question for the chairman. So if this motion fails, does that mean that this can't be brought up at a subsequent meeting because it's already been addressed?
Yes.
So it kills any opportunity to amend.
Mr. Chairman. And failure of the previous two motions kills any opportunity to amend. We're in an all or nothing proposition.
Okay. Vote aye.
Anybody else? All right, roll call.
Mr. Chairman, on the vote to sponsor 24 LSO 0076, lines 6 through 19 as in separate bill, Senator Beitman,
Aye.
Senator Brennan,
Aye.
Senator Rothfuss, Senator Steinmetz is excused, Representative Allred, Representative Andrew, Representative Berger,
No.
Representative Brown, Representative Claston,
No.
Representative Lawley, Representative Obermuller is excused, Representative Provenza, Co-Chairman Scott, Chairman Northrup. You have 6 aye and 7 no. Oh, I'm sorry, I can't count.
So it fails
Yeah.
to pass.
I don't think
6-6.
they want motions on the bill, is there?
662. Yeah.
It's 662.
And it's
Yes,
a
I
majority of those
apologize. It is also past my bedtime. You have 6-6.
Team. They got it. So it's 6:15. Mr. Brennan, I'm sorry that we're gonna have to drag you back here in the morning. I know you had a doctor's appointment. I was trying to get to it, but. So when we start in the morning, we are going to start with the update on the teacher retention and recruitment task force. First thing. Thank you. We are adjourned. Recessed.
Who's the gentleman? He's got